डिस्पोजल मैटर इसमें 5 आदमी का 4 आदमी को पैसा रिलीज किया, एक आदमी का लीगल है जिसका लिए पूरा किसको कितना देना है वो पैसा रिलीज नहीं किया।
No, I don't know what are you saying. Disposal matter.
डिस्पोजल मैटर,
It has been disposed of.
यस मैम।
So you have to file an IA. I do not know. ऐसे नहीं हो सकता. Can't be like this. The matter which has been disposed of, if you want any relief in connection with that, you have to file it. You have to file CMP. ठीक है. केस का नंबर लीजिए. Please see. I don't know, this order might not have been uploaded so far.
Unit issue WPC 2567 of 17. In this case, unit issue the respondents have forcefully taken possession of land of the petitioner and they have started construction without notifying the land for acquisition and
What
paying
is the
their
status of the
compensation.
What is the status of the case? Pleadings are complete?
The land was acquired way back in.
I am asking you, pleadings are complete?
Sorry.
Pleadings are complete?
Yes.
To what?
We have a small request under order
Supplementary list में डालिए.
under order 41 rule 11 there is one matter. Last item, the number 31. I was playing about it particularly before raising.
You will see. I cannot
There
see.
is an urgency in the execution case proceeding.
The execution case we have to see. You see, we are.
Not if possible, just not I'm just playing. Not if possible.
If you spare me, it may be possible.
No, serial 31.
From supplementary list directed cases for orders item 1 WPC
Mr. Mittal,
3539
your
of 1.
first matter is covered.
Because I first because I do not have a copy of
Right.
the brief.
I'll give you a copy.
If it is covered, because then.
You just have a look at this. I've given the judgment also. Yes, madam. Where is Mr. Sharma? You are there. Yes.
Before they start, little more submission.
Item 4.
As we have seen in the case of Arunachal Bombay versus Sami and others, quoted in 2000.
You've done this exercise. Yes, yes, that we have seen.
Yes, I just want to point out that it says that if the acquirer leaves mail issue, it will descend as separate property to that issue down to the page number 539.
Para 69.
539.
You are referring to para 69.
No, it is para, I think it starts at page, para 54, it starts at page number 537. Page number 539.
Para 54, 539.
Yes. The third para, I had read all this para yesterday. I just want to point one thing to Harsha, that it is said that if the acquirer, the third para, in the middle, if the acquirer leaves mail
Again, it is not pretended.
again it is not pretended that on the death of the acquirer of separate property, the separately acquired property falls into the common stock and passes like an ancestral property. On the contrary, it is admitted that if the acquirer leaves mail issue, it will descend as separate property to that issue down to the third generation. So my submission is that, Your Lordship, that it descended
You
as
complete reading. You read it complete.
Although therefore where there is a mail issue, the family property and the separate property do not descend to different persons, they would descend in a different way and with different consequences. The son taking their father's share in ancestral property, subject to all rights of the co-partners in that property, and the self-acquired property free from those rights. The course of succession would not be the same for the family and the separate state, and it is clear therefore that according to Hindu law there need not be unity of heirs. So what I wanted to point out, Your Lordship, that the property will descend as separate property down to the third generation.
You read para 55.
Para
55.
55. On a complete, Your Lordship said para 55.
55.
On a complete reading of the judgment of Privy Council in extenso, the following legal principles are called out. That the general course of descent of separate property according to Hindu law is not disputed. It is admitted that according to that law, such property, separate property, descends to a widow and in default of male issue. It is upon the respondent, therefore, to make out that the property here in question, which was separately acquired, does not descend according to the general course of law. According to the more correct opinion, where there is undivided residue, it is not subject to ordinary rules of partition of joint property. In other words, if it is a general partition in any part of the property was left joint, the widow of the deceased brother will not participate, notwithstanding with separation, but such undivided residue will go exclusively to the brother. The law of succession follows the nature of the property and of the interest in it. The law of partition shows that as to the separately acquired property of one member of a united family, the other members of the family have neither community of interest nor unity of possession. The foundation, therefore, of a right to take such property by survivorship fails, and there are no grounds for postponing the widow's right to any superior right of the co-partners in the undivided property. So, what I want to submit, Your Lordship, that the property descends as a separate property down to the third generation. If Surya Narayan Bose, the father of the plaintiff and the defendant, he acquired the property from Babulal Bose. So he acquired this property as a separate property, which means that he acquired the property in which he will have all the right of disposition. So the first succession opened in the year 1934 when Babulal died, and Surya Narayan Bose was the only male issue of Babulal. So he inherited the property, and that property would be considered as separate property according to the Hindu law, Your Lordship. So he has all the right of disposition. And the second succession opened in the year 1992 when Surya Narayan Bose died. So all the children, that is the daughter and sons, they acquired right in that property, being class 1 heir of the Surya Narayan Bose. So that is what I want to submit, that it is not an ancestral property, and they acquired that right in the remaining property.
The name of the ancestor is
Babulal. He is the grandfather. He died in the year 1934 or before.
died in 1934.
Yes.
Correct?
Yes.
Okay. And his son Surya Narayan.
Yes. That time
Died in
1992.
And according to you, upon his death, if there was any property surviving,
Yes.
it would have devolved upon his heirs.
Yes. Being class 1
But
year,
since he had already transferred the property by way of gift,
some of the property.
some of the property,
Yes.
not all.
Not all. Only some part of his property which he had inherited from his father. And that property will be considered as a separate property as per Hindu law.
So whatever property he inherited from his father,
Yes.
that was transferred by way of gift.
Only some of the.
Out of that also, some of the property.
Only, yes, some of the property.
What happened to the remaining?
They executed relinquishment deed in
In
respect.
connection with the remaining property?
Yes, the daughters. Yes, because yes, 35 bigas plus was gifted to all the brothers.
35?
Plus
Yeah.
35 plus
35 and odd.
Yes.
Bigha to
All the
brothers
sons. All the sons.
by gift.
Yes. In 1972.
And what about the relinquishment is for?
50 plus. 50 plus bighas. Exact.
Excluding the gifted property.
Yes. But their allegation is that they
They were called upon to relinquish the gifted property.
Yes. So there is no earthly reason to seek relinquishment of the property which is already their own property.
And the suit property includes the gifted property as well as the
Yes.
the entire property.
Yes,
That is
and both
35 plus 50. Suit
Yes, that
property
is
is 35
86.
plus 50.
So it nearly
86.
86. The date already I had given that when they had the knowledge of this gift deed. If your lordship wants after
That's
this.
it. Now you respond.
First,
You address the point of law first.
I will be addressing only to the point of law. Before my lord addressing to the point of law, I would like to, my lord, make a very humble submission before this call. That, my lord, the case pertains to Dr. Rex and both the courts, your lordship, particularly my lord, appellate court, has taken into consideration the recent judgment passed by the Honorable Apex Court in the case of Vinita Sharma versus Rakesh. And my lord,
You have a copy of that judgment?
yes, that is 2020, volume 1 SCC, volume 9 SCC, page 1. That judgment I will give you.
Okay. We'll see that.
Lord, my very humble submission to this honorable court, Your Lordship, is that, my lord, this case should not be, my lord, examined with a perspective, my lord, that it is an ordinary suit of declaration for relinquishment or, my lord, any gift deed. My lord, may kindly appreciate. This is a suit for partition, in which, my lord, certain registered deeds, my lord, like gift or, my lord, the relinquishment release date in the favor of the brothers. Those are also, my lord, there. And, my lord, Honorable Apex Court, Your Lordship, I will show that relevant para from, my lord, those my lord, judgment of the Apex Court, Your Lordship. That, my lord, if such document is on record, like, my lord, registered, or even if the registered document is on record, then the court has to, my lord, examine, my lord, minutely examine whether the purpose was to, my lord, abridge the right of a doctor or not. Those findings I will be, my lord, giving, my lord, showing from the relevant para. But, my lord, just to outline my argument, my submission before your lordship is that it is a suit for partition. It is not a suit, my lord, for declaration of, my lord, the gift deed as void or, my lord, the relinquishment deed is void.
Let us see the prayer in the suit.
Yes. And before, my lord, I proceed further. One food I would like to say.
Okay.
Yes. One thing I would like to my lord, say that there is no substantial question at all on this issue. That whether, my lord, the finding of the appellate court that it is primarily it is a suit for partition. There is no finding. There is no substantial question.
No substantial question of law is required for that purpose.
No, that is required.
We have to see the relief in the suit.
That is required, my lord, as because after, my lord, taking into evidence and everything, your lordship court has come to this finding.
We'll see the suit as it stands.
Yes.
Isn't it?
Yes. Let us see, my lord, what is the prayer daily pass. That is para 14. decree declaring the suit property or ancestral properties of plaintiff and defendant.
Just a moment. This is also a very important decree.
Yes, your Lordship may kindly see internal page 6 of the plaint I am referring.
Yes.
Declaring, did my lord find? Decree declaring suit properties and ancestral properties of plaintiff and defendant. A preliminary decree and partition declaring 1/8 share to the plaintiff and other defendant each of the suit property by limits and bound. Production of any gift deed by the defendant number 1 to 4 bearing number such and such is suited by father in their favor against the suit property may be declared void on production. And it is to be declared that the deed of relinquishment is put by plaintiff and her sister in favor of defendant number 1 to 4 is void and has no force in the eye of the law binding upon the plaintiff. But it was amended. My friend has rightly pointed out. It was later on amended by 15th of February 2010. This prayer was added initially. Yes, these numbers are added.
And this on was also deleted.
On production also.
No, on word was deleted.
On was deleted. Rather, the entire prayer has been amended and this has been made. So,
This amendment must have come when the written statement must have been filed and they have this property by virtue of it. That would have been the reason for amendment.
Yes, they have
Because the
opposed.
details of the deed is also mentioned.
Yes, I will be arguing those things. Very submission, my lord, I would like to make that this is not a suit for cancellation. This is a suit for partition. That is to be said. And my lord, when your lordship will analyze the terminology which we have given, my lord, it is not in dispute that the defendants and the plaintiff and the other the defendants, they are the own brother and sisters. It is not in dispute. So, so far as the genealogy itself suggests that it is a family issue. It is a family matter. Now, my lord, the question which my lord has framed was the first substantial question. Lord, your lordship may kindly see the first substantial question.
You see, we are not inclined to buy your argument that no such question of law arises.
No, I'm coming to that. What is the exact substantial question? Let us see the substantial question. The substantial question of law is that my lord, the net court can give a finding without framing an issue that it is an ancestral. It is not the substantial question that whether property is a self-acquired property.
That was the declaration that you were seeking. That was directly an issue because that was the declaration you were seeking. That was your first declaration that it is an ancestral property.
My lord, may kindly appreciate.
And you amended it. Initially, it was.
My kindly appreciate. My lord, may kindly appreciate. My lord, second appeal, your lordship. My lord is sitting in a second appeal, and that too, your lordship may kindly appreciate. There are two concurrent, my lord, the courts has heard. Thereafter, my lord, this substantial question of law is framed. My lord, if the substantial question of law, my lord has decided several cases, on time and often your lordship has said that the substantial question of law which is framed is to be answered. No, so further, even my lord, despite their opportunity, my lord, they have not framed that particular substantial question of law which they want to address.
Which they want to address.
Yes.
What should have been the substantial question of law?
No, I will not argue on that. I will not argue.
I will not frame additional substantial
My lord, may kindly appreciate.
I will not frame any.
I will argue on the
substantial
questions of law which has already been framed in this case. Your lordship may kindly see what is the substantial question. Whether both the courts have erred in recording a finding about the nature of property and ancestral property, without framing any issues in this regard. Now the question, Your Lordship, is that can the framing of issue is mandatory? Your Lordship, I will be relying on a judgment passed by our Supreme Court. 2009 SCW, I will be giving that citation. 2009 SCW, it is a well-known case. My lord has also relied on several times. The Bachas Nahar case. My lord, in that particular case, court has
2009 STW. नहीं ऐसे आप कोई भी citation
हम
don't
citation
take it that I know it.
I will
I don't know anything. Whenever you cite, you have to give me.
I can agree.
ऐसे
Your Lordship, it's a very serious proposition of law, and my lord had put up this case on 1030 itself. I can be accommodated.
what
I can be accommodated.
seeking?
I suppose some judgments which I want to last.
No,
It
you
can
should
be
not
given
just-
later. It can be given later.
You see, the point is that you are referring to a judgment which is not there with me.
Anyway, I will be
How do
referring.
I
I will be referring it to later. But my lord, it is well settled. It is well settled, my lord, in 2009 itself. I had argued, my lord, yesterday, my lord, when an issue can be framed. When an issue can be framed, that I am by. My lord, may I kindly see that my pleading, my lord, and their pleading first. My lord, may I kindly see. Plaintiff and defendant are the full sisters and brothers and member of a joint Hindu Vrindavan family. That is the first line which is there. And it is not in dispute also. Yesterday, your Lordship has also said, no, this is not in dispute. And we have given the genealogy. Babulal Ghosh, he was the common ancestor. He had a son, Suryanarayan Ghosh. He had a wife, Ahalya Devi. And my lord, these all my lord defendants and the daughters are plenty. They are all my lord the brothers and sisters. Then my lord, my pleadings starts, your lordship. The plaintiff and defendants are own, possessed and immovable property after inheriting the same. Since the death of their grandfather, father, mother, all occurred in 1956. This is very, very relevant, and that's why I am pointing it out. Though my lord, my learned friend, my lord, in the written statement has said that the Babulal died in the year 1934. But my lord, in the cross-examination portion, that is only one defendant, my lord, he has been examined for so far as the other defendants are concerned, there is only part submission. There is no my lord, supporting evidence, their evidence. And my lord, the DW in para 37, your lordship, has admitted that he is not aware about the death of my lord, the grandfather. So my lord, in absence of that, the date which is 1934, your lordship, it cannot be presumed. That cannot be presumed. And so far as my lord contention, your lordship, is concerned, that everybody died after 1956, that I have substantiated in the evidence also, and no cross-examination of
Is there
that.
any finding who died when?
Question is, your lordship, may kindly appreciate. Question may kindly appreciate which I am putting your lordship. My lord, their contention, your lordship, that my lord, father died way back in 1934. And your lordship may kindly appreciate, there was nobody born, my lord, it is only, my lord, the Suryanarayan Ghosh.
Remember, Mr. Sharma, when the additional substantial question of law was argued,
My lord,
you had yourself submitted
my lord,
that most of the points which is there is covered by the first substantial question of law.
my lord, may kindly.
And one such substantial question of law which was suggested on that day was whether the property is an ancestral property.
That is still the issue. I am coming to that, my lord. Allow me to argue what I want to argue. My lord, may kindly appreciate it. We are arguing a second appeal, your lordship, may
No,
kindly appreciate.
because you are arguing that first substantial question of law is only confined as to whether an issue was to be framed or not to be framed.
Yes, the reason I am saying so, my lord, the parties are admitting that it is an ancestral property. Your lordship, I kindly appreciate.
Okay.
And
Since the parties are admitting that it is an ancestral property, therefore, how do you say parties are admitting that it is an ancestral
yes, I am
property?
coming to that.
When the plaintiff himself is seeking a declaration that it is an ancestral property.
My lord, may kindly appreciate. What is an ancestral property? Let us discuss first. My lord has taken that note. Your lordship, the Devananda. Lordship, may kindly have a look on that. At the very outset, I would like to say, this judgment has nothing to do with the case which I am on.
No, I am on the
Yes.
principles.
Yes, I am only on the principles.
Only on the principles.
Yes. Your lordship may kindly see para 27. Yes. A few provisions which have been cited by the learned council from the book Mullah's Hindu Law, 20th edition, volume 1 are added. Inheritance never in avenge on the death of a Hindu, who the person who is in the nearest years become entitled at once to the property left by him. The right of succession vests in him immediately on the death of the owner of the property cannot, under any circumstance, remain in abeyance in the expectation of the birth of a favorable heir, where such heir was not conceived at the time of owner's death. Where the estate of a Hindu has rested in a person who is his nearest heir at the time of his death, he cannot divest the property except either by the birth of a preferable heir, and such a heir or a daughter who was conceived at the time of his death, or by the adoption in certain cases of a son to the deceased. Hindu compassion. Hindu compassionary is a much narrower body than the joint family. That is the first point I would like to add. It includes only those persons who acquire a birth and interest in the joint compassionary property. These are sons, grandsons, great-grandsons of the holder of the joint property from the time being. In other words, the three generations next to the older in broken male descent, above proposition must be read in the light of what has been stated in the note of the top of this chapter. After the amendment of Hindu Succession Act in 2005, a daughter of co-partner has been included as a co-partner along with the sons of the co-partner. Commentary will now have to be accordingly. To understand the formation of co-partnership, it is important to note the distinction between the ancestral property and a separate property. Property inherited by father from his father. I would like to pause here. Property inherited by a Hindu from his father, father's father, or father's father is an ancestral property. Property inherited by him from others in a separate property. Essential features of essential property, ancestral property is that the person inheriting it has a son, grandson, or great-grandson. They become joint owner co-partners with him. They become entitled to it due to birth. These propositions must also be read in the light of what has been stated more at the top of this chapter. Prior to coming into force of Hindu Succession Act 1956, if A, who has a son, B, inherited property from his father, it becomes the ancestral property in his hand. B becomes a co-partner with his father. Though A has a head of the family was entitled to hold and manage the property, B was entitled to have an equal interest with his father. A, and to enjoy it common with the B, with him. B could therefore restrain his father from alienating it to except in exceptional cases, special cases where the alienation was achieved by law, and he could enforce partition of it against his father. On father's death, B took the property by the right of survivorship and not by succession. Ancestral property is a species of co-partnership property. As stated above, if the Hindu inherits property from his father, it becomes his ancestral property at his hand as regards his son. In such a case, it is said that the son becomes a co-partner and with the father as regard to property so inherited, and the co-partnership consists of father and the son. However, this does not mean that the co-partnership can consist only of father and son. It is not only the son, but also grandsons and great-grandsons who acquire the interest by birth in the co-partnership. The conception of joint Hindu property, joint family constituting a co-partnership is that of a common male ancestor with the linear descendants in the male line, with 4 degrees counting from the inclusive of such ancestor. No co-partnership can commence without a common male ancestor, though after his death, it may consist of politics. But what I want to contain is that this is the property of Malati Babulal Ghosh. Babulal Ghosh, Malad, their claim, Malad, is that, and our case also is that Malad, the father, Your Lordship, he inherited it. Now the question, Your Lordship, I want to put to myself. What is the nature of the property which the Surya Narayan Ghosh inherited from his father? Malad, as per the readings which I was just making, it is admittedly an ancestor. Qua his sons. Lordship may kindly appreciate it is qua sons, and later on your Lordship has taken note of that also. Lord, so, and my Lord, the judgment which my learned friend is derived.
It is an ancestral property in his hand, but so far as his sons are concerned, he constitutes a co-partnership with his sons.
Yes.
With respect to that.
Yes, and apart from that, my learned friend is the judgment which she is relying on. That is a judgment, my Lord, in which, my Lord, the father has executed a will. That is 1953 Supreme Court. The judgment she has also. I have the copy which she has given to me. Lakshmi Pandey.
She has given a book of list of books. Is it there in 53?
That judgment I have not mentioned, and right. Yesterday I have not said about that judgment, but it is there and it will also make it clear about what is ancestral property.
But it is the compilation which she has given me. It is at page 31, my Lord will find. This is same judgment, 1953, 244. Did my Lord find it?
She has not given it. For me that copy is not there. इसका copy नहीं.
244 the page हम लोगों को दिया है इसमें दिखा दे. वो अभी जो जजमेंट दिया.
Yes, I am seeing. 244.
Yes. Is it 244?
No, it is 495. AIR 1953 SC 495.
AIR 1953 Supreme Court.
Yes.
It is, my Lord, may kindly see the judgment, my Lord, which I want to place.
Which judgment you want?
It is Arun Chala
Yes, yes, it is 495.
Okay.
Yeah.
Then his case will be.
Which para you want to place?
Yes. First thing which I would like to say, what was this case? In this case, father had executed the will. So, gift. Property gifted by father to his son would not become ancestral property in the hand of the son simply by reason of the fact that he bought from his father. It is not the case here. In this particular
She is not relying upon this judgment.
anyway, but it is one of the landmark judgment that is the reason why I am placing it. It's a foundational judgment with respect to Malad this ancestral and compassionate property.
Which paragraph do you want?
Yes. Lord, in the compilation which she has given me, substantial point that requires consideration in the appeal is
This is of SCR 1954.
whether the
But I
property
have
is
not
that
been given any 1954 judgment.
No, I have not given.
Yes, no,
she
has
may not have given, but this is a base judgment.
Yes,
which
you
I would
just
like to
refer
solve.
to the
But
paragraph.
what we are deciding a proposition of law.
Certainly,
It can
you
be-
refer to the paragraph. I'm absolutely looking at the judgment. You tell me
The
which paragraph.
substantial point that requires consideration
that?
in this appeal is whether the property that the defendant number one bought the will of his father or to be regarded as ancestor or self-acquired property in his hands. If the properties were ancestral, the son would become proportional with their father with regard to them, as it considered that the other items of the movable property were mere accretions to his original nucleus, the blends cannot plaintiff must succeed. If the other hand, the bequeathed property could rank as a self-acquired property in the hand of the defendant number one, plaintiff must fail. The law on this point, as the courts have pointed out, is not quite uniform, and there have been conflicting opinions expressed upon it in the different high courts, which require to be examined here.
I'm not able to get the paragraph here. You give me the paragraph number.
This is Supreme Court
I'm
report
just-
1954.
I just do not know. He's not giving me the paragraph number. You are referring another citation which is not there. From where do I read it?
That is what he has not given the correct citation.
He has given me the book and you are having a separate something else.
He is having Supreme Court reports.
Judgment is
SCR.
Judgment is same, but from where do I read it?
Yes.
You
it
give
will
me
be
the
different.
paragraphs which I have to read. If it does not match with your print,
I can understand.
then where do I read it?
I can understand. Anyway, Lord may take note of this.
I will not take note of it unless you place it. बताइए कहाँ पर है? ऐसे ऐसे हम आपको एसएससी ऑनलाइन का डॉगल दे देंगे पूरा पढ़ते रहिए. ऐसे नहीं होता. It can't be like this.
हम निकाल नहीं पाए.
आप हमको पैरा बताइए कौन सा. The citations which are not placed in the court, I will not take.
10:30, my lord, and such a serious case.
आप ऐसा करें चीफ साहब को बोलकर टाइमिंग चेंज करें.
नहीं, सब के
आपको लगता है कि सिर्फ आप ही पढ़ते हैं, हम लोग नहीं पढ़ते हैं.
ऐसा
हम लोग भी पढ़ के आते हैं ना, तो इसीलिए it is not an excuse 10:30 बजे केस लगा.
But these are the minor issues. Some judgments are.
I'm absolutely giving you full audience. और आपको इतना ध्यान से सुनते हैं क्योंकि आई नो दैट यू विल नॉट आर्ग्यू समथिंग व्हिच इज बियॉन्ड लॉ. तो आप हमको ठीक से जजमेंट नहीं बताइएगा कहाँ से पढ़ेंगे. इतने बात का रिप्लेस करिए आप. अच्छा, आपका जो जजमेंट है ना, जो आपके पास प्रिंट,
ये इनके पास है.
अच्छा रुकिए हम फाइल लगा दें. इसका जो एससी का ये जो एआईआर का प्रिंट है ना, एक कॉपी निकाल के लेंगे. ठीक है.
सर
आपके साथ इतना पूरा बटालियन है, किसी को बोलिए खोलने के लिए.
I can understand. Please understand how it is.
हाँ बोलिए.
Anyway, I will not.
You see, if we take it like this, that if it is a self-acquired property of the grandfather, and if it devolves to his son,
I'm coming to it. Law I have already stated. Now, my lord, one judgment which my friend has not given, the main judgment which I want to Lashmi, may kindly have look on this judgment. It is Shyam Narayan Prasad. My lord, may kindly see Bharat.
Bharat bhai?
Bharat. It is settled law that the property inherited by a male Hindu from his father's father, or father's father's father is an ancestor. That what I was reading, my lord, from the Buddhas. My lord has already taken note of it. The essential feature of an ancestral property, according to Mitakshara, is that sons, grandsons, and great grandsons of the person who inherited it acquire any interest and the right attached to such property at the moment of their birth. The state, the share which the ecopartner obtains a portion of ancestral property, the ancestral property, as regard his male issue. After partition, the property in the hand of son will continue to be ancestral property, and the natural adopted son of that will take an interest in it and likely to be by the survivors. In the CT Krishna Prasad, CIT, this court has considering a similar question. In the said case, C. Krishna Prasad, the appellant along with his father Krishna Swami Naidu and brother C. Krishna Kumar formed an undivided family on 13/10/1950. When there was a partition between Kuruna Swami Naidu and his two sons, the question arose to whether the unmarried Hindu on partition of a Hindu family can be assessed in the status of an undivided family, even though no persons beside him is a member of the family. It was held that the case that the share in which the co-partner obtains a partition is an ancestral. As regard the male issue, it was held the share which a co-partner obtains on partition of an ancestral property is an ancestral property as regard his male issue. They take on interest in by birth, whether they are in existence at the time of partition or are born subsequently. Such shares, however, is the ancestral only with regard to his male issue. Such share, however, is ancestral only because as regard the other relation, it is a separate. That's what I was saying. Now, Lord, he has referred, I will read further. If the co-partner dies without leaving the male issue, it passes to the heir by succession. A person who for the time being is the sole surviving co-partner is entitled to dispose of the co-partner property and it will be a separate property. He sell or mortgage without legal necessity or payment. The second part is very relevant to this mechanism. If his son is subsequently born to him or adopted by him, the alienation, whether it is by sale, mortgage, gift, will nevertheless stand for the son. Cannot object to alienation by before he was born or given. But once he is born, he can. In Yogendra versus Lima, that judgment I have also brought. Kindly see this judgment also, which has been referred. It is now well settled, in view of the several decisions of this court, that the property in hand by a sole co-partner allotted to whom in partition shall be his sole property for the same shall revive only when a son is born to him. The moment a son is born, it won't be separate. The more times to come, Malad, it won't be separate. And Malad, it is not in dispute. Unless you may kindly appreciate that it is not a self-acquired property of Surya Narayan Ghosh. It is a property of the grandfather. His case, Your Lordship, is that he has inherited it. Now the question is, it is admittedly an ancestral property with respect to his sons. What other relations it can be? This is the judgment, which I am relying on both the judgments of Yogendra and others versus Dinaman and others. And my Lord may kindly see the judgment passed by the apex court. That is in the case of my Lord Vinita Sharma and Rakesh Sharma. Lord may kindly see case Lord is having SEC online, SEC 2000, SEC 9, volume 9 SEC. Yes,
Para 22.
para 22. A joint family is a larger body than a co-passion. Did my Lord find?
Yes. Yes, continue.
May I continue? Before I proceed further, I would like to say, in this particular judgment, my Lord, all these judgments have been considered, and now, my Lord, you see what is the settlement? Has not been disturbed till date. That's my mind. If it has been disturbed, my learned person friend can point it out. A joint Hindu family is a larger body than the Hindu Kupash. A joint Hindu family consists of all persons lineally descended from common ancestor and include their wives and married daughters. A joint family is one of the worship and for hold joint hands and joint assets. After separation of assets, the family ceases to be joint. Whether severance in food and worship is not treated as a separation. As observed in Ravnath Anugrah Bhima Dev Kesari Bhattiswaj, Hindu co-passionary is a much narrower body. It consists of a progenitors with 3 linear descendants before 2005. It included only those persons like sons, grandsons, and great-grandsons who are the holders of the joint property. For example, in case A is holding the property, B is his son, C is his grandson, D is a great-grandson, E is a great-grandson. The co-passionary will be up to D. And only on the death of A, the holder of property, the right of E would ripen in the co-passionary as the co-passionary is confined to 3 linear descendants. Co-passionary property is one in which inherited from the Hindu. Para 24 is also relevant. It one inherited by Hindu from his father, grandfather, great-grandfather's property inherited from others held in the right cannot be treated as a forming of co-passion. Others from others he cannot, but the property in the co-passionary is held as a joint. Co-passionary gets rights by birth. Another method to co-passionary by way of adoption. Then the formation of co-passion. From interpreting the provisions of section C, it is necessary to ponder how a co-passionary is formed. The basic concept of co-passionary is based on the common ownership by co-passion. When it remains undivided, the share of the co-passionary is not certain. Nobody can claim with precision the extent of his right in the undivided property. Co-passionary cannot claim any precise share as the interest in the co-passionary is fluctuating. It increases diminishes by the death. In Sunil Kumar vs. Ram, court discussed essential features of co-passion. Those who are individualistic attitude and separate co-passionary may find it hard to understand the significance of Hindu family and joint family. But it is there from the ancient times perhaps as a social necessity. A Hindu joint family consists of male members descended linearly from a common male ancestor together with their mothers, wives, and widows, and unmarried couples. They are born by the fundamental principles of Sapinda's was the family relation, which can essential figure of institution. The thought that needs the members of the family is not the property, but the relationship of life. The co-passionary consists of only those persons who have taken by birth an interest in the property of the holder or who can enforce a partition whenever they like. It is a narrower body than a joint. It commences with a common ancestor and includes a source, a holder of a joint property, and only those males in the male lines who are not removed from him by more than 3 degrees. This is the reason why the co-partnership is so limited to be found in the tenet of Hindu lineage. And only male descendants of the 3 degrees can offer a spiritual ministration to an ancestor. These males can be co-partners. In case of co-partnership, property comes to the hands of a single person. Temporarily, it would be treated as his property. But once a son is born, co-passionary would revive in the terms of Mitachara. In the Sila Devi versus Chand, it was observed that the principle of law applicable in this case is so long a property remains in the hands of a single person, the same was to be treated as a separate. Thus such a person would be entitled to dispose of the proportionary property as the same thereof. But if a son is subsequently born to him or adopted by him, the alienation, whether it is by sale, mortgage, or gift, will be nevertheless stand for the son, cannot object to objections made by the father before he was born. But once a son is born, it becomes a compulsory property and he would acquire an interest in it. Not what I want to contain you. Surya Narayan Ghosh may have inherited property from his father. That what is the case that is being argued by the other side. But I will show it from the evidence of D.W. that the grandmother was alive. We have said so. We have in the plaintiff have also said so. Grandmother was alive, and the defendant, the only defendant who has been examined, that is D.W. He could not say what is the death of the father, the grandfather. Though they have said that in the 1934, but I will refer to para 37 of his cross-examination. He could not point out what is the exact date. The grandmother was alive.
Nor there is any finding. We are not going into this fact.
It has been treated to be a ancestral by both the courts. They are what
Point is, it is an ancestral property, whether it is a compulsory property.
My lord, may kindly appreciate.
It is an ancestral property.
My
It is
lord-
an ancestral property even at the hand of his son.
My lord, may kindly.
But whether it is a compulsory property is something which is to be examined.
My lord, may kindly appreciate. Two more things I would like to say. Your Lordship, first, I would like to clarify that it is a property of a grandfather. And the relinquishment deed, which they got executed by misrepresentation, that later on was cancelled also. That is with respect to the grandfather's property. Your Lordship, kindly appreciate. So, my lord, if for a moment Your Lordship kindly appreciate, suppose there is no gift or deed on record, and my lord, there is no relinquishment deed on record as well, whether I am entitled to partition or not. I am putting a simple question to myself. For a moment, my lord, assume that there are no gift deeds on record, and my lord, there is no relinquishment deed also.
Yes, you are entitled.
I am entitled to partition.
Yes, that's right.
Your Lordship may kindly appreciate. And that what the Supreme
But
Court.
the properties which have already been alienated.
Yes, that I will come to that also.
And that too by a registered
I will come to that, madam.
not challenged at a particular point of time.
I am coming to all
And if
this.
there is a partition to that property, then how will it work?
I am coming to that. Your Lordship may kindly appreciate. The first thing, Your Lordship, is that if the sons are not entitled for the property of the Surya Narayan Ghosh, where was the occasion for a gift deed? I am putting question to myself. But if somebody is already
See,
entitled-
where was the occasion? We are not going to question that.
No, I'm putting a question.
Deeds
but
are
Your
staring at us that he executed a gift.
My lord, may kindly appreciate. I am putting a question to myself in the light of the judgment rendered by the mother, the Vinita Sharma case. Your Lordship may kindly see that
Complete
paragraph.
the placement of Vinita Sharma. Will it reopen the concluded transactions?
Yes, my lord. That what is it? Yes.
Please show me
Yes,
where
yes.
it is that it will reopen the concluded transactions.
I'm saying so.
Yes.
Your Lordship may
And
kindly-
irrespective of the fact whether the challenge to the concluded transactions have become binding.
What Supreme Court has said, Your Lordship, that my lord, merely by my lord such creating such documents or even if
It is not a creation of a document,
It is-
it's a registered deed.
Your Lordship, that is invalid. That will I will show when I will argue that.
Does it become void ab initio? It is a voidable document.
It will be void ab initio as because
In the year 1994, did they dream that the daughters will become co-pastors in the property and therefore there should be a collusive
yeah, my lord may
document?
kindly appreciate. My lord may kindly appreciate. What is the right of a daughter prior to 2005? Your
She
Lordship
is a
may-
member of a joint family.
He was a member of a joint family.
That's
My lord, he has a right in the father's property.
Yes.
If suppose there is a partition, even national partition is made, and if a share is allocated to the father, then in that share, all the sons and daughters used to have the same this share.
No, not
So
in,
that-
not in co-pastoral property.
No, I am not on the co-pastoral
So
right.
therefore,
If suppose
you see, you are on the one hand saying that upon death of the grandfather,
no, my lord asked me.
and by virtue of the presence of the grandsons, the property was a co-pastoral property of the father and the son and the grandson.
What I want to say, not one of the parties will be disputing that it is the property of Manad the Babulal house. After death, Manad, his case your lordship is that Manad his son has inherited. Now the question your lordship is if the son is even if has inherited, and his case is that it was in exclusively, but though the mother was alive, the widow of the Manad the Babulal was alive, which she has also written in notes given by her that she was alive. Then in that view of the matter, this Surya Narayan Ghosh cannot have an exclusive right. That is the first thing that I would like to say. Second one, my lord was asking me that I was putting to myself a question that what was the occasion, my lord, for the gift deed. Your lordship, the occasion was, my lord, that even the father was not inclined to give, my lord, the share to the daughters. My lord is aware about the stark reality in the Hindu society. My lord is aware. And my lord, such a decision has to be rendered by the apex court. Your lordship may kindly appreciate the
You see,
intent of the
the father
legislature.
was not inclined to give the property to the daughter.
Yes, that was the reason.
That was the reason.
That was the reason. And my lord, it is not unusual. It is not usual. We have a patriarchal society. And in a patriarchal society, your lordship is well aware what happens. What happens? My lord, this case has to be seen with that angle also. My lord, may kindly appreciate
We
too.
see it from with that angle. Has the court seen it with that angle?
Yes, the court has seen it, but
was that you see the gift deed being manufactured and with that that the daughters will be completely deprived, assuming that
I
in
won't say
2005 the
manufactured.
daughters will become a co-partner.
My lord, may kindly appreciate. I will not say manufactured, but I will say invalid. I will show how it is invalid.
You see,
One by
one. The point is,
one by one.
Point is, you say it is invalid.
Yes.
Now,
I will issue void.
How does it become in issue void?
Yes.
If there is an alienation by a co-owner, if there is an alienation, suppose, so just a moment, Mr. Sharma, if there is an alienation by a co-owner of the property, and if that by a registered deed, and ultimately there is no challenge to that deed, the deed becomes void and issue.
My lord, may kindly appreciate, my lord, 6 section 122 of the transfer of property. What are the ingredients required for a valid deed? That has to be seen at least. Your lordship may kindly see what is the 122. Gift defined. May I read? Gift is the transfer of certain existing movable or immovable property made voluntarily and without consideration by one person called the donor to another called the donee and accepted by or on behalf of the donor. Acceptance when such acceptance must be made during the lifetime of the donor and while he is still capable of giving. All these ingredients are, your lordship, is not available. Why I am saying? My lord, love and affection mentioned, they were minor, but there is no representation also. There is no representation also. And there is no acceptance. How a deed can be valid? Father died, my lord, as per the learned friends, my lord, statement also, and it is a matter of regard. He died in the year 1992. Gift was way back in 1972. What, my lord, prevented the father or, my lord, the other side not to accept it? A deed, my lord, who has not been accepted, how it is valid? That is the first point. Second one, gift is in the nature of the in the favor of the minors. I agree to this proposition that the property can be acquired in the name of the minor, but it not the way it has been acquired. It must be through some representation. How a property can without who will accept on behalf of the minor? So keeping all these things taken into record, the learned trial court has said that it is wide an issue wide, and appellate court has also confirmed it. These points have been taken into consideration by both the courts. Can a gift, even if registered, it has any existence in absence of acceptance? No. So that way, it's an invalid gift.
Who will accept the gift when the father is executing the gift
That's
in
why-
favor of his son?
What
He
I am
is the
saying,
natural guardian.
such a gift has no existence in law. There should be some representation. They could have filed an application to appoint a guardian, to appoint
That
a
is not the contour of the case.
appoint a proper.
Please do not expand the contour
Then-
of the case to that. That is not the reason assigned. That is not the reason
The
assigned by
reason
the court.
assigned your lordship is that it is invalid. And the things which I am just arguing, that you are in favor of a minor, and that such gift is not cannot be such gift. Those have been discussed by the well discussed judgment by the trial court. I will place those judgments and has been affirmed by the appellate court also. Such gifts are invalid gifts, and my lord is well aware. In case of the Honorable Apex Court has said, in the case of Prem Singh versus Birbal, if something is valid only, then only it comes for limitation issue. Otherwise, not. So this very document, your lordship, is itself invalid. And my lord, may kindly see, my lord, the relevant paragraph which I wanted
You
to
see, when the gift deed is specifically challenged,
it is not. I have.
there is a clear-cut challenge. You cannot read words into it.
My lord, may
There is a clear-cut challenge with respect to the gift deed and the relinquishment deed, and you are seeking partition of the property which are covered under the gift deed and the relinquishment deed.
That's what
You
I am
are
saying.
conscious of the fact that these deeds are standing in my way.
That-
And whether this gift deed is valid, invalid, whether the transfer was for any necessity or no necessity, or what was the occasion for transfer, and how the relinquishment was done, whether it is by way of misrepresentation or fraud, etc. These are matters of evidence.
That has been let out.
That has been therefore it is not a void document. The point is that whether suppose there is a gift, there is a deed of the year 1944, and a person wants to challenge it that it is on account of misrepresentation, correct? And he wants to challenge it after 100
So
years.
far as we-
No, let us see this. If he wants to challenge it after 100 years, right? The defenses are gone. That is the whole purpose of having a limitation.
That what has been said in this Vinita Sharma case, madam. Such defenses has to be examined by the court, madam,
That's
carefully, and both the courts after careful examination
So
has said so.
what prevented these ladies to challenge the deed of relinquishment within the period of
It is
limitation?
within period of
No.
No, it is within period.
No.
Your Lordship,
You see-
may kindly see, madam, the 109 of the Limitation Act.
You
Your Lordship,
see,
may kindly see 109 of the Limitation Act.
they say that there was a fraud committed.
My lord, may kindly see 109 of the Limitation Act.
Yes. What is the period of limitation?
May kindly see what is the limitation for challenging this. Under 9, your Lordship, may kindly see. By the Hindu governed by Nitakshara law to set aside father's alienation of ancestral property. 12 years.
12 years.
12 years.
So gift deed is barred? No, let us come one by one. This is father's alienation. Father's alienation by father. So alienation by father, even if it is against the co-custody right of a person,
I am coming to that. Let one by one. May kindly see first the
this
relinquishment.
will not govern the relinquishment deed.
This will govern the relinquishment.
How? How will it
Because
govern the relinquishment deed?
Not-
Relinquishment deed is executed by the daughters.
Yes,
Yes.
yes.
This is not an alienation by father.
Anyway, I will be coming to that. I will coming to that. So far as the relinquishment deed, your lordship is concerned, the relinquishment deed, your lordship, is of 1994.
When was the suit
And there
filed?
was a cancellation deed also.
Who bothers about that cancellation?
Anyway, my lord was, had already.
When was the suit filed?
Suit was filed in the year 2005.
2005.
Right.
What happened in 10 years?
10 years.
Yes.
10 years, my lord, several things happened.
Might be, but the point is that you say that there was a fraud and you were misled.
My
You
lord,
have a copy of the deed. You execute a cancellation deed also. It means that you are conscious of this fact.
I was conscious of fact of that there
Then?
is some misrepresentation. That is the reason why a cancellation deed was disputed.
It is of no use.
No, it's of use.
No use.
I
No,
will show
no.
that. I will show that also.
No, that's not
I will show that.
If that was of use, what was the occasion to challenge it in this?
I am not challenging that one. My lord may kindly appreciate. I am asking my share.
You are asking your share
I am
in
asking my
connection
share.
with which you have already executed a relinquishment deed.
My lord, both the courts, your lordship, has concurrently held
Therefore,
that concurrently had that it has no legal sanctity in law.
and what is the finding of both the court on the point of limitation?
Limitation, the
It's
court
void
has
ab initio.
no, I'm saying
No limitation is
your
possible.
lordship may kindly appreciate. So far as the trial court, your lordship is concerned, trial court has considered the limitation period of 12 years also. I will show it. I had shown it from the trial court judgment, and my lord, today also I can show. I will show it. So far as
12 years so far as relinquishment deed is concerned.
12 years of cause of action.
Sorry,
Cause of action.
cause of action. You see, it is not relatable to cause of action. From where does the court gets cause of action? You see, wherever there is a cause of action, it is provided in the Limitation Act.
My lord may kindly appreciate. There is a difference when somebody is in possession and somebody is out of possession. I would like to
You are in
examine.
possession.
So far as the member of the joint family and member of the everybody has joint possession. So 3 years period will not be the proper limitation.
You will. So you want to say that you will challenge your. You see, the moment you execute the deed of relinquishment, right? Legally, you are dispossessed of the property.
My lord may kindly appreciate.
You cannot claim joint possession in spite of executing a relinquishment deed.
That's what I am saying. The relinquishment deed is a nullity in the eyes of the law, and everybody is in joint
Not
possession.
nullity, Mr.
Joint
Sharma.
possession.
This is too far-fetched.
No, it's
We
a
cannot
judgment
know.
passed by two courts. I will show those judgments.
That is
of
why
the
you
trial
in
court
second
also.
appeal.
Trial court, I am saying.
That is why in second appeal. If the judgment of the two courts is binding on us, there is no point. You cannot ignore limitation with regard to relinquishment deed.
Lord, I will be arguing on the questions of limitation. I will be arguing. First point I was arguing what will be the nature of the property. Nature of the property. That the nature of property will be ancestral.
I have got it. Nature of property is ancestral.
Ancestral.
According to you,
No.
is it co-custody
No.
or is it only ancestral property?
What I am saying, my lord, that the moment, my lord, the son is born in the family, my lord, the father cannot have the absolute right. Because it is a property
So
from
you
the
want to
Babu
say, you want to say that with respect to the property of grandfather,
Yes.
the son and the grandson,
My lord,
they
if
constituted a
if
co-custody.
if the son is not born, and if in the integram, my lord, if the property ownership comes to the hand of the father, then my lord, it may be treated as his separate property.
That's
But my lord, the moment the son is born, then the situation would be other.
so co-custody existed.
And in this
You
particular,
just see at that point of time, the co-custody existed amongst whom? Amongst the father
and his son.
and his sons, right?
Father at the moment, my lord, if suppose for a moment what I am saying, that admittedly it is Babu Lal property. Babu Lal property, they inherited this Surya Narayan Ghosh and his widows. His widows, I will show it from Para 37. Now the question is, if the son is born in a family, then the property no more remains the separate property. Then how it can be a self-acquired property of the
It is immaterial. The point
if it
is,
is not a
the
self-acquired.
point is there were 4 sons in the family, and the entire property was transferred by way of gift
No,
in,
it
with
has two
respect
parts.
in favor of 4 sons.
It has two parts. Lakshmi kindly appreciate. The Sur property comprises of several villages, etc. It comprises of 2 parts. For one part, the father has disputed again in their favor.
See,
So far as the other part
technically, on the date of death of grandfather,
Well,
there was a proprietary in connection with the father and the grandsons. Correct?
I'm
Yes
getting
or
further.
no?
I'm
Yes
getting-
or no?
My lord, may kindly
There was a proprietary between the father and the grandsons.
My lord, I would like to go further now, even if there is no capacity. But my lord, if the moment my lord, the Surya Narayan Ghosh, my lord, inherited the property, and the sons were born, my lord, then there was a capacity.
There was a
So,
proprietary.
And as per
Proprietary
the
consisted
2005
of
Act,
proprietary consisted of whom?
my
The
lord,
father and the sons.
Surya Narayan Ghosh and his sons and
And his
daughters also.
sons. Sorry.
Daughters also now, I believe.
Now daughters.
Yes.
But in the when the gift was executed way back
72.
in 72, at that point of time, as the law prevailed, right? The proprietary was between the father and the grandsons.
Yes.
Only, right? By virtue of this gift, what is the father doing? The father is relinquishing his rights.
No, father
Father
is
has
giving
gifted,
it.
no. He has gifted, so he is divesting himself of any right over this property.
My lord,
And he is exclusively vesting it. And after and once the gift is made, the father could not have dealt with the property.
I bow down to your lordship that my lord has come to the right point. Your lordship. May kindly appreciate. The moment your lordship will see that it is an ancestral, as per the judgments and the arguments which I was just making. My lord, the father cannot execute a gift deed with the consent, without the consent of the persons with whom, because they are also co-sharers. That aspect has also been taken into
They are
consideration.
not co-sharers.
No.
You see, since they are not co-partners.
They are co-partners. Grandsons, I am saying.
Yes, they are.
Sons, I am saying.
Yes,
If
sons.
father is disputing a gift deed in favor of sons, without their consent, how can a minor of 1 year can give a consent? I am putting a question to myself. That has been taken notice by both the courts.
He is
and
giving gift to them only.
No.
Yes.
That is not permissible. That can be.
You want to say that the father cannot give the property to
Then
his
it
son?
can be gifted through as per what is permitted under the law. There should be some representation. How can a minor of 1 year or 2 years he can accept, or how a minor of 2 years can give a consent, or even to giving consent, as per the Contract Act, it must be a measure. So these aspects has already been taken notice and considered by the learned court, and both the courts has come to a finding that this deed is absolutely void, no requirement. No requirement. Both the courts have come to this finding. And as because it is an invalid deed, no question of limitation. My lord, may kindly allow me. This is one judgment, it's a landmark judgment.
If with respect, if it is one thing to say that some transaction is especially void evidence,
My lord.
but once it is challenged, you cannot ignore. Like you see in the case of Prem Singh,
My lord.
what happened? It also involved the rights of a minor, right? At the end, what did the court do? The court said that the minor had to challenge it within 3 years of attaining his majority. And having not done so, it was barred by limitation.
My lord, may kindly.
So therefore, merely because it is found that the person is a minor, that does not
No,
will not render the registered deed void ab initio. It does not become void ab
My lord,
initio.
may kindly appreciate. So far as we are here, my lord, on the gift, not on the sale. That is the first point I would like to say.
No,
in
therefore-
a gift, this very gift ballot has no legal existence. As because my lord may kindly see. The sons are minor, there is no representation, there is no acceptance, my lord, there is no consent.
These things has been dealt with in the judgment.
And after dealing with, the court has come to a finding that the document is invalid. And my lord is well aware, the verbal seal case also. If something is invalid, means invalid, nullity in law. Where is the question for challenge, which is a nullity? Why should I challenge it? That's what I'm saying. But and apart from that, Your Worship, there are judgments of this Telangana High Court, Honorable Chief Justice, our Honorable Chief Justice, Ms. Ramchandra Rao judgment I would like to say. But in a suit for partition, cancellation of daily deed as such is not required. Para 83 I would like to see. The Lordship may kindly see para 83.
How many sisters were there?
4 sisters.
And how many sons?
4 sisters. My lord, 1/8 share has been rightly given by the trial court, my lord, and found by the appellate court. My lord may kindly appreciate one thing. 90 bigha lands. 50 they have virtually, my lord, got relinquished. कुछ तो देंगे. It is not their right. Your Lordship may kindly appreciate. My lord may kindly appreciate. I would have said nothing.
Sympathy से कुछ नहीं होगा.
No, I would have said something, my lord. I would have
No
said.
sympathy beyond
My
law.
lord may kindly say this. I would not have said anything. Had it been the property of Surya. It is not the property of Surya. Even gift is not valid because when the widow was alive, widow of Babulal was allowed. How the whole property or any property can be excluded without the consent of the widow? There is no consent in the gift deed also. Like widow died in the year 1959. That has come in evidence.
Were the gift deed executed during the lifetime of the daughters? After
Yes,
the daughters
yes.
were born?
Yes,
What was the date on which the daughters were born?
that has also come in the court's. That is not in dispute. Everybody has born after 1956. And rather it has come in the evidence that when the father executed a
The
gift deed.
daughters were born after 1956.
Yes, everybody. They have the right, my lord, as per the new act, they have the right that what is the ratio laid down by the apex court. It's not so easy to abridge their rights, my lord. That would I humbly say. And my lord, such judgments, your Lordship may kindly appreciate. Such judgments, my lord, are rendered by the trial courts, your Lordship, and appellate court has been found. It has come after a very long time, such judgments. Considering the stark reality of the Hindu society, my lord, if the daughters have been given right, my lord, my humble submission, there are 2 judgments passed by the courts, my lord, it should not be interfered by the High Court. That too in a second, on such a technical issues. Your Lordship may kindly see by page 83 of the judgment rendered by Honorable our Justice, Chief Justice M.S. Ramachandra Rao.
Page number?
It is page number 17.
Yes.
Lord, para 83 article considered. Here in this case also the brothers have cheated. In view of the above discussion, prima facie hold that the suit for partition without a pillar for cancellation of said deed is quitted by co-partner of the plaintiff without authority maintainable at the intent of the plaintiff. And by limitation of the ground, it was not within 3 years of date of alienation, does not form a facie arise. This is because the relief of cancellation of sale did not even be prayed for. Not be prayed for. And Malad, in this particular case,
Read the next also.
Malad,
In any event, the issue of bar of limitation has to be raised and decided.
they may raise it.
If
Raising
the,
is not
the
raising.
point is that if the issue of limitation is irrelevant, then where was the question of raising and deciding?
Lord, may kindly appreciate. This is a suit for partition. That's what I got my first argument. And in a suit for partition, but if there are certain registered dates or even some family arrangements, or as per the Honorable Apex Court judgment, now it has to be closely examined. Let us see Malad that para. Malad, may kindly see 2000 Malad.
Which para?
Para 137 I would like to say. Once after examining several aspects of the matter, now the Supreme Court has said. Before that, I would like to read para 135. Lakshmi, that has been relied upon by the learned appellate. A special definition of partition has been called. Read para 5. In the explanation. The intent of the provision is not to jeopardize the interest of a daughter and to take care of sham or frivolous transactions. Set up in the defense unjustly to deprive the daughter of her right as a co-pastor and prevent the nullifying the benefits flowing from the provisions as substitute. The statutory provision made in the section 5 changes the entire complexion as to the partition. However, under the law that prevailed earlier, an oral partition was recognized. In view of the change of provisions of Section 6, the intent of legislature is clear, and such a plea of oral partition is not to be readily accepted. The provisions of Section 5 are required to be interpreted to cast a heavy burden of proof upon the proponent of oral partition before it is accepted as a separate occupation of portions. Appropriation of income and consequent entry in the revenue records, and invariably to be supported by the other contemporaneous public documents admissible in evidence, may be accepted as most reluctantly while exercising some steps all safeguard. May be accepted most reluctantly by the Lakshmi while exercising all safeguards. The intent of Section 6 of the Act is only to accept the genuine partitions that might be taken place under the prevailing law and are not set up as a fake defense and only in ipsi dixi is to be rejected outright. The object of preventing setting up of a false or a frivolous defense to set at naught the benefits emanating from the amended provision has to be given fully. Otherwise, it would be very easy to deprive the daughters of a right as a co-pastor. When such a defense is taken, the court has to be very extremely careful in accepting the same. And only if cogent, implicable, contemporaneous documentary evidence in shape of public documents in support are available, such a plea may be entertained, not otherwise. We reiterate, the plea of an oral partition or a memorandum of partition, unregistered, one can manufacture at any point of time without any contemporaneous public document needs rejection at all costs. We say so that exceptionally good cases where the partition is proved conclusively, and we caution the court that the finding is not to be based on the preponderance of probability in view of the provisions of gender justice and regards of the very heavy burden of proof which meets the intendments of explanation to Section 5. It must be remembered that the courts cannot defeat the object of the beneficial provisions made by the Amendment Act. The exception is carved out by us as earlier exclusion of a registered document for partition was not necessary. And court was rarely approached for the sake of family prestige. It was approached as a last resort when the parties were not able to settle their family dispute amicably. We take note of the fact that even before 1956, partition in the other modes as envisaged under Section 6 had taken place.
This is all in connection with oral partitions.
No. Registered document I am saying. What happened?
Even if the partition is by way of registered document.
My lord, may kindly see page 137.
Yes, I am seeing 137. You read 137.
Hmm?
Will it cover all any alienation, or it will cover only the oral partitions?
No, it will cover, my lord.
You just
Yes,
show
I'm
me. You
ready.
show me
I'm
that
ready. The
all the
expression
alienations
will be-
made, maybe sale deed, gift deed,
I'm
alienation
saying-
deed, executed by registered document, that will be covered by this, and the court has to scrutinize and see whether
Yes.
that particular deed, way back 50 years back, maybe 20 years back, whether that is by way of to circumvent or deprive the daughters of the right to property.
My lord, in the facts and circumstances of this case.
No, show
But
me,
in
when you are
fact-
citing
Yes,
this
yes,
judgment,
yes, I'm citing
will it
it.
reopen all the previous transactions, irrespective of the period of limitation, irrespective of the nature of transaction? Will it reopen everything?
That what I am saying is, if there is some document on record for such a defense, then it has to be scrutinized. What I am arguing. Your Lordship may kindly see expression used in explanation to section 5. Partition decree by partition effected by a decree would mean giving final effect to actual partition by passing a final decree. Then only then it can be said that a decree of court affects partition. A preliminary decree declares share but does not affect actual partition. That is effected by passing a final decree. Thus, statutory provisions are to be given full effect. Whether partition is actually carried out as per the intent of the act is to be found out by the court. Even if the partition is supported by a registered document, it is necessary to prove that it has been given effect to and acted upon and not otherwise sham, invalid or carried out by the final decree of the court. In case partition in fact has been wiped out, finally in toto, as it would have been carried out in the same manner as if affected by the decree of court, it can be recognized, not otherwise. A partition made by exclusion of deed duly registered under the register also refers to completed event of partition, but merely in treatment of section 5 conferring rights, merely to separate is to be borne in mind that while dealing with the special
You see,
provisions.
the entire discussion is with respect to the explanation to section 6 within bracket 5.
Yes.
Section 6 within bracket 5 is nothing contained in this section shall apply to a partition which has effected before 20th day of December 2004. So you cannot read in this section all the
I
alienation.
have not read what the Supreme Court has read.
No, we are
And
looking at
Supreme
it.
Court
We are looking at it. Supreme Court is not
Supreme Court
really,
now, my lord, has
Supreme
said.
Court is not saying that all the transfers
No, no.
made, all the transfers made will come under the scrutiny irrespective of limitation.
My lord, may kindly
No,
approach.
Mr. Sharma, it is too far-fetched. We will not reopen all the transactions already
So
settled.
far as the facts of this case, Your Lordship is concerned. Facts of this case, Your Lordship is concerned. I am confined to my facts. My lord, what is the impediment for the partition in this particular case? I am putting a question.
The impediment is that the property has already
There are
been
two
transferred.
impediments, Your Lordship. The first impediment, Your Lordship, is the gift deed. Second, Your Lordship, is the relinquishment deed by us. For a moment, Your Lordship may assume that there is no such document. Whether I am entitled for partition?
What is the date of institution of the suit?
2005.
2005.
Yes. Now it
That's
cannot.
right. You see what happened? These daughters, they executed relinquishment deeds, right?
Under the misrepresentation.
Whatever be the misrepresentation, the moment the misrepresentation comes to light, you have to challenge it.
My lord, may kindly appreciate.
You have to challenge it.
My lord, may kindly.
And the date of knowledge of
My lord, may
misrepresentation,
kindly appreciate the
the
daughters.
limitation will commence from that period. What has happened in this case is, the moment 2005 amendment has come into force, the daughter acquired the status of co-passery. They challenged the relinquishment deed by saying that the intention of the daughters is not correct in
My
this
lord,
case.
may kindly.
They will not
Had it been case,
That is the case.
No. Had it been the case, there was no occasion for cancelling the relinquishment. Not may kindly appreciate. There are two properties, may kindly appreciate. Both the properties are of Babula records. Malad, for one property, father Malad excluded a deed. Now Malad, the brother Malad, in order to grab entire property, Malad, got Malad relinquished the property which was of grandfather. And under the pretext that basically you are relinquishing your rights with respect of the gifted property. This what is the case? I am not apprehending this. Your
What is the date of knowledge that there is a misrepresentation?
Admittedly, in the 1994.
In 1994, what did you do for 3 years?
Madam,
What did the daughters do for 3 years?
that has been taken not by the appellate court and the trial court. I will note out those paras from the relevant judgment. Right now, I am the law. But under 37, I would like to read. Provisions contained in substituted section 6 of the Hindu Succession Act confers status of a co-partner on a daughter born or before after the amendment in the same manner as with the son with the same rights and liabilities. Rights can be claimed by daughters born earlier with effect from 1995 to 9/9/2005 with savings that are provided in section 1 to the dispositions or alienation, partitions and testamentary distribution which has already been taken place 20th day of 2004. Since the right in a co-partner is by birth, it is not necessary that the father co-partner should be alive living around 9/9/2004. Statutory fiction by partition created by provision as originally enacted did not bring about the actual partition or disruption of co-partner. The fiction was only for purpose of ascertaining the share of the deceased co-partner when he was survived by a female class 1 as specified in Schedule 2 1956 or male relative. Provisions of substituted section 6 are required to be given full effect. Notwithstanding that the preliminary decree has been passed, the daughters are to be given share in the co-partner equal to that of the son in the pending proceeding for a final decree or in an appeal. In view of the regards of provisions of section 5, it is a plea of oral partition cannot be accepted as a statutorily recognized mode of partition effected by a deed of partition duly registered under the provisions of the Registration Act or affected by a decree of court. Only two things now the Supreme Court is saying. Here there is no registered partition, deed of partition. And Malad, there is no decree of court also. So that appellate court has taken note of this judgment and all these aspects has come to a finding. There is unity of title in position and Malad accordingly has declared 1/8 share to one of the daughters. You may kindly see one judgment, it is 2002 SCC 112. In this particular case, Your Worship, Honorable Apex Court has considered.
This is on court fees.
No, it is on a very serious issue. There is a difference when a person seeks a relief for cancellation and a relief for declaration that the such and such deed is not void. Your Worship may kindly see parasite. Where the student of a deed wants to be annulled, he has to seek cancellation of the deed. But if the non-executant seeks annulment of deed, he has to seek a declaration that deed is invalid or non-est or illegal or that is not binding. The difference between a prayer for cancellation and declaration in regard to a deed of transfer conveyance can be brought out by the following illustrations relating to A and B, two brothers. A excludes a deed in favor of C. Subsequently, A wants to avoid this. A has to sue a cancellation deed for cancellation. On the other hand, if B, who is not the executant of the deed, wants to avoid it, he has to sue for a declaration that the deed executed by A is invalid, void, and non-est illegal and he is not bound by it. In essence, both may be suing to have deed set aside or declared as non-binding, but the form is different and the court fee is also different. If A disputant of a deed seeks cancellation of the deed, he has to pay ad valorem court fee on the consideration is retained. If the B, who is non-disputant, is in possession and sues for a declaration that the deed is null and void and does not bind himself, he has to merely pay a court fee of rupees such and such. But if a non-disputant is not in possession, he has to seek not only a declaration of a said is invalid, but also a consequential relief of possession has to pay an ad valorem. So what I want to contend with, there is a difference between when somebody asks for cancellation and something is not binding. Here in this case, what the prayer is that as because those are impediments, so it is not binding on us. That
You are seeking a declaration of setting aside of the alienation deed which was executed by you, not by anybody else. So in view of this judgment that you have to,
I'm sorry to reply.
you were seeking a declaration that the deed executed by you is null and void. This is the prayer. So far as deed of alienation is
declared that
concerned.
the relinquishment is put by plaintiff
Yes.
and her sisters in favor of the
That's
defendant
right.
is void
So
and has
how-
got no
how
aid
does
in
it-
the force of it.
That's right.
No cancellation.
Even if you, what do you mean no cancellation? When you read this particular judgment, it says that it has to be cancelled.
My lord, may kindly understand.
This is not
In
your
a suit for partition, this is primarily a suit for partition. My only prayer was that such.
You want to say if it is a suit for partition, all the registered deed, you can just go and get it declared null and void. There could be transfers, there could be gift, there could be so many kind of allegation.
But if suppose there are gifts on record, there are documents on record. But when my lord, the Honorable Apex Court and the legislature has granted my lord, the right to the daughter support. And when the Apex Court has said, that those deeds has to be scrutinized, and when the two courts have
थोड़ा
already
ऐसा नहीं लग रहा आर्टिकल 14 ज्यादा ही हो गया
नहीं,
कि ये registered deed हो गया time barred
registered
हो
deed
गया
is valid.
then also will court
it is valid.
has देखेंगे
हाँ,
हाँ सुन लिया हम आपका I have understood your argument
इसमें
but the
हम-
limitation will not apply on this
the limitation will not apply. हम इसमें कुछ
yes
दिखाएंगे।
void ab initio तो limitation का काम नहीं
और हम इसमें और भी दिखाएंगे इसको किसी और दिन अगर आज नहीं
नहीं आप कितना दिन आप
नहीं,
सुबह से सुन
इसमें
रहे
और-
हैं
आप इसमें और है
और कुछ नहीं
one more day I will take. It's an important right to Lashmi Kandi.
yes I'm appreciating it so it's an important right
What right?
which has been crystallized
Crystallized.
through many things
Yes. And so far as the first part, my lord was putting a question to me with respect to
it's a very serious case Mr. Sharma correct very serious case I am posting it tomorrow कल अपना written submission लेकर अब ये मैं बोली कि नहीं ऐसा नहीं चलेगा ना देखिए एक केस में काम करिए और पूरा कंप्लीट करिए नहीं तो हम नहीं देंगे टाइम हम सुनेंगे साथ
हम लोग को
साथ
सुबह से समझो तो शाम हो जाता है
सुबह से शाम हो जाता है हमको नहीं होता सुबह से शाम
कुछ तो
आप
हम
भी
लोग
तो
को
सुबह से शाम होता
कुछ
है
तो मोहलत दिया जाए
नहीं कोई मोहलत हम नहीं
In this particular case, Your Lordship, I did not study anything except this case for the whole night.
You can argue for 5 hours without studying. I just I had
I am arguing the question. इसमें हजूर हम एक दिन का मोहलत और था
वो कल की
परसों रखते हैं।
नहीं परसों नहीं रखें
कल
नहीं देखिए आई टेल यू वन थिंग मिस्टर
इसमें हम एक शॉर्ट नोट
देखिए इतना कॉम्प्लिकेटेड इश्यूज रहता है जैसे ही हम दूसरा केस में आप अपना माइंड को डाइवर्ट करते हैं आई नो
I relate to have a memory like yours.
You see, no, I
not
don't
an
have,
exception.
no, I don't think that I have a good memory. The point is, Mr. Sharma, कोई भी केस कंटिन्यूटी में सुनने से जजमेंट बढ़िया होता है।
One day will not break. One day break more hours.
नहीं, break हो जाए।
My lord wants to
नहीं,
do it
नहीं,
tomorrow. I want
see,
day
I
after.
tell you one
Day
thing.
after tomorrow.
नहीं,
That would be
नहीं,
that would be compatible.
No.
Your Lordship, I kindly appreciate there are other cases also. Some other cases also. I am to Malad.
You charge your fees as much as you can, but the point is that you cannot shift from one.
No, I'm not shifting at all.
My mind doesn't shift that way. My mind doesn't work in that manner. Please,
My
Mr.
lord,
Sharma, appreciate.
My lord, मैं
हम आपको इतना ऑडियंस दे रहे हैं, I don't think that मतलब I can't do more than this. And उसके बाद जो है इतना
asking
कंटिन्यूटी में चीजें चल रही हैं, उसके बाद हमें थॉट प्रोसेस को ब्रेक नहीं कर सकते. Mr. Sharma, you see, please consider.
I agree for it. My lord, मैं कहीं
सेकंड हाफ में रखिए.
Second half.
second.
आपको इसके अलावा कुछ बोलना है तो
हाँ,
अभी
बोला
बोलिए.
हम लोग सब आर्गुमेंट याद करके कर लेंगे. कुछ लॉ पॉइंट तो बोलना फाइंडिंग होता है.
One thing, madam, if it is found that when the father executed the gift deed and the sons and daughters were born in the family, then under such circumstances,
Your Lordship, I will come to the definition of Hindu co-partners. Who can be Hindu co-partners?
that we have seen.
No, Your Lordship, I will show it to my Lord. It is the Mullah's Hindu law.
Unless the third generation is born, they do
Yes,
not
that
form
is-
a co-pastorate.
Yes, that is what this judgment which I had referred, I had given the list. That only Justice, Honorable Justice S.B. Sinha, he referred to Mullah's Hindu law, and in Article 230,
Anyway,
Hindu
we
co-partnership is defined. So I'll just read out a few lines. Hindu co-partnership. A Hindu co-partnership is a much narrower body than the joint family. It includes only those persons who acquired by birth an interest in the joint or co-partnership property. These are the sons, grandsons, and great-grandsons of the holder of the joint property for the time being. In other words, the three generations next to the holder in unbroken male descent.
Unless the third generation comes into picture, there is no co-pastorate.
No, that is what the definition is as per Mullah's Hindu law.
That's
And
right.
yes, and
It
that
is,
what-
it is, suppose there are fourth, fifth and sixth generation, then they will not form a part of the co-pastorate because they would stand excluded.
yes, it will like
Does it mean that unless the three generation is complete, the property is not a co-pastorate property?
No, unless it becomes an ancestral property, they become
You see, it
co-partners with
becomes
respect
an
to-
ancestral property in the hands of grandson.
Yes, the three generation next to the holder, then after three generation, that is what it says. In other words, the three generation next to the holder in unbroken male descent. If the property is divided, like if it comes to the first generation,
The point is,
yes,
it says that it is till the third generation, right?
yes.
It excludes the fourth generation and onwards. Correct?
No. After that, it becomes an ancestral property, and it will continue down to the third generation as ancestral property. It becomes ancestral property for the fourth, and they will become the co-partners then. Unless there is an ancestral property, they acquire, they become co-partner by birth only with respect to the ancestral property. Your Lordship. It has to be ancestral property. So that we have to see. Here, they are not co-partners right now because
In the
it is
hand
not-
of the father, the
Yes.
property of the grandfather is not ancestral property.
No, it cannot be termed. What is
It has to be termed as what property?
it-
Self-acquired
it-
property?
Yes, because as I
It
read
will
out
become-
from the judgment of Honorable Supreme Court in that 2022, it says that only when it descends down to the third generation as separate property, like if it gets divided, like if it is descending to the first generation and he alienates the property.
I'm sure Mr. Sharma does not agree with you.
No, because he will not
I have given
definitely.
a judgment, my lord. Supreme Court judgment.
No, that is the Supreme Court. I am also
Sorry.
relying on Supreme Court, and we
Tomorrow
have
we are
to see.
staying for 2:15, right?
It will finish tomorrow because
It will finish tomorrow.
because-
For sure,
because
it will be taken up till it is over. Even post
I'm much
4:30 we will
obliged.
continue with this.
I'm much obliged.
Even beyond 4:30 we will continue till it is over.
I'm much obliged.
The counsel for the respondent has commenced his arguments. The arguments have remained inconclusive At the request of the learned counsel for the respondent, the matter is directed to be posted tomorrow at 2:15. And is to be heard till the matter is over.
How much applies?
कल खत्म कर देना मैं उनको भी कर देना and it will be heard till the matter is over irrespective of any time constraint 4:30 बजे के बाद ही चलेगा
How much applies?
Okay.
Also, to item 1, from supplementary list, WPC 353/2001.
Is it covered?
That's, there is only one issue, Manoj. The issue in the Supreme Court judgment was whether they were entitled to any exemption under the industrial policy. Because under the industrial policy, it said that if your contract demand exceeds 500 kVA, then you are not entitled to the exemption. The exemption was that if it is below 500 kVA, you will
It
get.
has not held that this is valid.
Plus, the validity of clause 16.5 of the tariff was not under question before the Honorable Supreme Court. The fact was that your contract demand had exceeded 500 kVA, it was 612 kVA in 1 month, and therefore you will not be entitled to the exemption under the industrial policy, which was that if it is lower than 500, you will not have to pay AMG for 5 years. In the writ manner, we've challenged clause 16.5 of the 1993 tariff, which says that if your contract demand exceeds 110% of the existing contract demand, it will be the new contract demand, and your AMG bills will be assessed accordingly. It will be calculated accordingly. We challenged the AMG bill because it was calculated on the basis of 113 kVA, whereas our contract demand was 100 kVA. I have also made indicate one thing was that the first order in the writ says that there is no prayer for interim relief, therefore no interim relief was given. So in all probability, this writ has become infructuous because for 25 years, if they have not paid the AMG bill, the factory might also have closed. I am only saying it may be kept tomorrow, we will take instructions, and if it is infructuous, we will withdraw it, Malas.
WPC number 3539 of 2001. The learned counsel for the petitioner. At the request of the learned counsel for the petitioner, the matter is directed to be posted tomorrow. As first case, 10 days. This court, in this judgment, certain other judgments have also been referred. Please examine as to whether in those judgments this kind of provision has been examined.
Well, I will also indicate that I was just checking Annexure 3 to the writ petition, where we say in the writ petition that similar matters have been interim relief or similar matters have been filed, and there's a reference of a CWJC 1999. But when I checked that CWJC, it seems that CWJC has been disposed of already.
Where is that?
Annexure 3, Manoj.
You have got the copy of the order.
No, the case status simply shows that it is disposed of. That first CWJC
इसको
number
जरा
of
पता
1999.
है इसका record मंगा लेते हैं. Office is directed to place the records of CWJC number 2342 of 1999 within bracket R and analogous cases. कब हुआ disposal? Date पर
No,
पता है.
it does not. The case status does not say that. It just says disposed of.
Which, as per the case status, has already been disposed.
Yes, please.
ठीक है? इसके साथ ये record.
It seems, Manoj, it has become infectious because 16.5 of the tariff has been used throughout, Manoj, and the law is that if it is more than under 10%, it becomes a contract demand. And if
This
it
is how it is.
it is how it is, Manoj. It is how it is.
First question.
Item 2, WPC 6025 of 2001.
Yes, petitioner. Yes, ma'am.
Leadership after the state leadership private respondents also, and in the last state leadership, the private respondents were directed to bring the record of the title suit leadership.
So they were issued notice to the concerned police station. Therefore, the state.
Yes.
Did you seek instructions to file an appeal?
Leadership of
Why not? This matter is pending since 2001.
yes, leadership earlier this matter was in some other office where this leadership now it has been allotted to our office leadership. But the first time I was waiting for the state in this matter.
Actually, in 2001 matter will not apply.
It was last taken on 9/7/2025, and on that day leadership it was the private correspondence were ordered to
Where is the petitioner? Why should the private respondent bring the order of the receipt?
leadership. No leadership.
If the petitioner wants to rely upon it, they have to bring it.
Yes, leadership.
What is the big idea?
No leadership it was ordered in the last state leadership that's what I am wanting.
The civil suit and the appeal was passed by which court?
Leadership was passed by DCLR and leadership DC.
No, the suit.
Title suit.
That is suit. Which court?
It has not been mentioned leadership. In the petition leadership it is only mentioned the number of the title suit and title appeal.
Yes. Which court has passed?
It is not mentioned in the leadership only in point number 4 leadership on page 6. Only it is mentioned the title suit number 3048 oblique 48 of 1955 56 and the title appeal number 35 oblique 3 of 1957. It is mentioned in this leadership.
It seems that the petitioner is not interested. If they are not interested, we'll dismiss the case. Why should we bother? Isn't it? If the petitioner is not interested, we'll just post it and dismiss the case. If they do not appear, we'll say that they are not interested. They can't just not come. Mr. Deepen will announce. You said wait for some time. Maybe he's busy in some other booth. Otherwise, he has a good office. Number of juniors are there in his office. Somebody will definitely come. You wait for some time. You just find out from this why this service report of the police station has not come. That was your responsibility. And said this, whether these people are alive or dead, we do not know. They are fighting since 1957.
The father of the petitioner died in leadership 2022.
And so he has been substituted.
Yeah, he has been substituted leadership. Right. Last time, nobody was appeared with the private respondents also leadership. Earlier, the name is there in the respondent. But the private respondent is Chandrasekhar Prasad and
They will come here just for you. So, the moment they come, you just let me know. The moment they come, you just let me know. Call 20 minutes. Samiji.
Item 3 WPC 5945 of 2001.
होते हैं ट्रैवल करके अल्टीमेटली आपके पास है।
आप एक बात हमको बताइए, इतना एलिगेशन है फ्रॉड का, इतना एलिगेशन है कि इट्स फोर्ज एंड फैब्रिकेटेड डॉक्यूमेंट, हाउ डू वी डिसाइड इट विल बी
विदाउट एविडेंस फ्रॉड का केवल प्लीडिंग से नहीं
फ्रॉड
होता।
का क्या एविडेंस देंगे?
यू विल हैव टू कि कब ले गया,
रिट
कैसे
में
क्या
कैसे
किया।
होगा? रिट में कैसे? रिट जुरिसडिक्शन में ये कैसे?
रेट जुरिसडिक्शन
Can
में
we
तो
really
रेट
decide?
जुरिसडिक्शन में तो नहीं होता।
नहीं हो सकता। You see, either of the party, आप भी पोजीशन क्लेम कर रहे हैं, वो भी पोजीशन क्लेम कर रहे हैं, जिसको ग्रीवांस है वो अपना सूट फाइल करे।
सिंपल रेट का यही है कि if there is dispute of title and possession,
Yes,
go to civil court.
there is a dispute of title and
Yes.
possession. You go to ये यहाँ नहीं रिजॉल्व हो
Right
सकता।
is
एफिडेविट से थोड़ी डिसाइड हो जाएगा। देखिए,
My case is blood settlement of 1934 has been,
do I really need to give the background of the case?
yes, sir.
It
That we
should be
have,
sufficient to quote the relief, and then I'll say that there are allegations, counter
then
allegations.
only the first prayer, so far I remember,
Yes.
before your lordship, that let the matter, since it is an old matter,
Yes.
there are so many supplementary affidavits, counter affidavits, etc. Let it be put up on 27th, I will give it. Note along with the judgment
Judgment on what?
on all the that yes. So the allegation was that it is forest land, declared forest land, protected forest. But subsequently it was released. And that is being
वो
disputed
जो
by
रिलीज
state.
वाला जो डॉक्यूमेंट है ना,
है।
सेक्शन 5, 6 and 7,
Annexure 5.
तीनों चीज को वो बोल रहे हैं कि फोर्ज एंड फैब्रिकेटेड।
Forged and fabricated.
उसमें जो साइन किया है उसके बारे में बोलते हैं he never existed as that
Yes,
authority.
that is their plea.
This is their plea. कोर्ट से ऑर्डर था कि नोटिफिकेशन लेके आइए, इन्होंने नोटिफिकेशन लगा दिया। ठीक है, दैट नोटिफिकेशन
वही
इज नॉट अंडर
notification
चैलेंज।
हम केवल हमको एक दिन का टाइम दिया
हम
जाए।
आपको जरूर देंगे।
हाफ एन आवर में डिक्लेयर कर देंगे कि जो नोटिफिकेशन लगाया है उस समय उसको पावर था। And I have got the certified copy.
So the point is, notification है, gazette notification, उसको पावर था नहीं था, that notification is not specifically under challenge in this particular proceeding. एक जो gazette हो गया notification, फिर हम उसका legality, validity, power
Only
without any
it
specific
is
challenge.
their document. It is their.
Maybe it is their document. If suppose sir there is a gazette notification which comes through the counter affidavit and you say that this is null and void, he did not have the power to issue a
This is
notification.
document. My submission is that subsequently it was released. It was released by DFO.
Release पर बहुत question mark है.
Certified copy
इनका
we have.
एनेक्सर 5 में मिलोड कोई पोस्ट एग्जिस्ट नहीं कर रहा है।
इसीलिए हम चाह रहे
जो
थे।
लगा रहे हैं ये
इसीलिए हम चाह रहे थे।
There was no post as such. हजारी बात का नोटिस।
हाँ नहीं ठीक है। DFO को पावर था नहीं था वो और प्लस नोटिफिकेशन दैट दे हैव annexed in their counter affidavit.
जमींदारी रिटर्न वगैरह भी नहीं है इसमें।
जमींदारी है
नहीं कहाँ है अब जमींदारी रिटर्न? हम तो बोल रहे थे कहाँ है जमींदारी?
नहीं रिटर्न नहीं है रिटर्न
नहीं है,
अब रिटर्न के बाद
कोई जमींदारी रिटर्न नहीं है,
नहीं
कोई
रिटर्न
ऑर्डर नहीं है। By which order you were declared to be the रैयत, वो ऑर्डर नहीं है।
रसीद है जमींदारी का रसीद है हुक्मनामा है
कब का है वो डेट भी नहीं है। आपके एफिडेविट में कहीं नहीं लिखा हुआ है कि वो कब इशू हुआ।
1934 का है कि
नहीं देखिए सर, आपके एफिडेविट में नहीं है, पढ़ के पता नहीं चल रहा, तो हम कैसे समझेंगे 1934 में जमींदारी रिसीट इशू हुआ? वो सारे डॉक्यूमेंट्स आपने जो सप्लीमेंट्री एफिडेविट में लगाए, देयर इज ओनली वन सेंटेंस that the collected documents are annexed. थोड़ा समय लगाए हैं इस रिकॉर्ड में, समझने का कोशिश कर रहे हैं।
Rejoinder to counter affidavit has been filed that.
Yes.
उसका तारीख इसीलिए हम चाह रहे थे।
नहीं ठीक है, हम आपको टाइम देंगे, टाइम इज नॉट एन इशू। आप जरा देखिए रिजॉइंडर टू काउंटर एफिडेविट, ठीक है, एक सप्लीमेंट्री एफिडेविट आपने फाइल किया है। You see, supplementary affidavit dated 10/7/2025. Just have a look at it. Para number 2 इससे क्या हम derive करें? ये xerox copy of 2 हुकुमनामा, then further report of Amin 26 rent receipts कब का date है क्या है
that was settlement.
Sir, from where do I find out किसका कौन सा date है?
Yes.
कुछ foundational
नहीं
statement
ठीक है, हम
नहीं।
इसका शॉर्ट नोट बना के दे देते हैं।
और ये जो डॉक्यूमेंट्स आप लगाए हैं एक भी नहीं पढ़ा रहे हैं। ये लग रहा है कि किसी केस में एग्जिबिट भी हुआ है। आई डू नॉट नो
नहीं वो क्रिमिनल केस में, इसके अगेंस्ट में 4-5 क्रिमिनल केस में,
किसी केस में एग्जिबिट
सब में एक्विटल हो गया।
अच्छा, आपका जमींदारी रिटर्न नहीं है?
जमींदारी रिटर्न नहीं,
ठीक है, वो जो आपका रेंट फिक्स हुआ उसका कोई प्रोसीडिंग नहीं है, उसका कोई ऑर्डर नहीं है, कैसे है?
ऑर्डर है, एरिक्शन फाइल देखा जाएगा, एरिक्शन
एलिजिबल फाइल को फोर्ज एंड फैब्रिकेट,
इसीलिए हम चाह रहे हैं
सिविल कोर्ट में डिसाइड होगा इसका, दैट इज दी ओनली रिमेडिंग एज पर so many judgment have been passed by the apex court
WPC number
East Court.
5945 of 2001. The learned counsel for the parties are present. The learned counsel for the respondent has submitted that serious objection has been raised in the counter affidavit, stating that the documents, some of the documents annexed in the writ petition are forged and fabricated. He submits that even the zamindari return and the order regarding fixation of rent has not been placed
and
on record.
so far I remember in one case जमींदार of Hazaribagh, वो राजा कामाख्या नारायण थे, he has not quite returned. उनका डिस्प्यूट चला गया था सुप्रीम कोर्ट में, इसलिए रिटर्न फाइल नहीं हुआ। लेकिन we are taking the stand here, possession given, rent receipt issued,
The records
and we are
also,
coming in.
the records also reveal that both the parties are claiming possession with respect to the property. दोनों ने
They are not claiming, they are possibly claiming after some year.
That's
state
he
level
has
return
submitted that the dispute involved in this case cannot be decided under writ jurisdiction. The counsel for the petitioner seeks adjournment and submits that the matter may be posted on 27th. 27th.
एक मेरा
Post on 27th as per case.
मेरा एक आग्रह है, तो मेरा अपना भतीजा एक्सपायर किया है, इसलिए 10, 11, 12, 13 हमको मतलब रहना पड़ेगा वहाँ, पूरा में रखना पड़ता है। 27, 28, 29 का करेंगे कि थोड़ा बीजिए, इसलिए
पहले रख देते हैं।
कब रख?
22 को सर?
हाँ, ठीक है, हमको कोई दिक्कत नहीं।
22nd in the
लेकिन I will come with the note along with the
Yes, please come. 22nd, first case at 10:30. Correct?
22, yes.
सर तो आ जाते हैं, अब आपके बारे में नहीं बोल
नहीं, हम तो क्या है कि 10 बजे हम पौने 10 बजे हमेशा पहुंचा जाते हैं, ऑलवेज, केस रहे न रहे बात।
All right.
From there is targeted cases for final disposal item 1, second appeal 4 of 2004.
In this case, I have given an implement slip also.
forward.
But there was an order passed by your lordship, note on 24/11/2025, order number 21, by which notes some of the additional questions were framed and some of were rejected. Against that notes, we have moved SLP notes.
SLP number.
Yes, note. So the diary number is 528 of 2026.
When was it filed?
5th of January 2026.
528 of
26 notes.
filed on?
Filed on 5th of January 2026.
What is the present status?
But यही हमको भेजे हैं वहाँ से. This is
second appeal number 4 of 2004. Counsel for the appellant has submitted that one SLP has been filed against order DT 20.11.2025. Bearing diary number 528 of 2026, filed on 5/1/2026. The computer generated receipt has been produced before this court, which is kept. Pose this case on 27 January. The SLP number will be provided. SLP का number दे देंगे उसके बाद का.
Orders item 2, 7 April 64 of 1995.
उसमें एक IA फाइल की है.
That is.
But I have filed an IA note, IA number 111 of 26.
Yes, what is it for?
Yes. Not in this note, prior to this IM notes, we have filed an application under Order 22 Rule 10A, seeking direction upon the respondent to give the details of death of some of the respondents. Pursuant to which note they had filed an application stating that respondent number 9 have died in the year 1994. That is prior to notes the second year, 1994. Notes on that affidavit, the notes we have filed this application.
This respondent number 9 was defendant number?
Defendant number 9 notes.
He was defendant number 9 also?
Yes. I will just check date and date. No, 16, sorry. Defendant number 16.
He was pro forma or contesting?
But ऐसा तो यहाँ लिखा नहीं है लेकिन हाँ. Because it's a partition suit. So partition suit में pro forma हो या contesting होगा, share है, family का है, तो share है. And the suit was dismissed. In appeal, the suit was declared. I am the defendant in the suit.
What is the date of dismissal of suit?
But the date of dismissal of suit is this is 28th May 1985.
Dismissal of appeal?
Yes. 9th August 1995.
1990.
Yes. So prior to this process, during pendency of title appeal, respondent number 9 herein, who was defendant number 16, have expired, where they were the appellants in a partition suit arising out of they were the plaintiff, and they have not filed a substitution application. And then her name figures in the decree also. And on that note, we have filed an application that since it has been passed against a dead person, therefore it is a nullity. And therefore, note we have.
I'll reply.
What reply?
You
You have given the date of death.
I will bring the several judgment lots. Unfortunately, lots I have not brought the file lots. There are several judgment of the
Is it several for less than
next week, Suraj.
Is it not a nullity?
I will bring the judgment lots.
That it is not a nullity.
Therefore, my submission is that there are several judgment that matter may be remanded to learned.
Why should we demand?
Like there is a judgment.
If it is a nullity, you take steps.
Yes, that is what.
They may whether you see if the full brother is dying and the person is not filing substitution, why should it's a conscious exercise not to substitute.
My prayer is that this case may be taken up next week. I will bring the judgment lots.
What?
हमारा फाइल छूट गया है, हम जजमेंट निकाले हुए हैं. रियली में मेरा जजमेंट हम रॉन्ग सबमिशन कभी नहीं करते हैं. मेरा जजमेंट है, इनको भी हम कल शाम को फोन किए, हम बोले कुछ हम जजमेंट
फाइल नंबर में छोड़ देंगे.
नहीं बोले, इनको हम बोले
आपको ये बोले खाली कि आप
जजमेंट
हम जो है इसका रिप्लाई फाइल करेंगे.
नहीं रिप्लाई करेंगे, कुछ जजमेंट भी मेरा है.
ओके, आई एम
नहीं, हम रिप्लाई नहीं फाइल करेंगे, हम इसमें जजमेंट के लिए देंगे. कि पार्टिशन सूट में इसमें क्या इफेक्ट होगा क्या नहीं होगा।
But I have annexed a coordinate bench judgment with this IA.
I will also कम से कम 10 जजमेंट हम निकाल के रखे हुए, छूट गया हमारा फाइल। 10 जजमेंट हम कम से कम रखे हुए हैं, लेटेस्ट जजमेंट भी है इसमें
कि नलिटी नहीं हो।
नहीं नलिटी होगा, मतलब उसको रिमांड कर दिए करके फिर वहां से होगा।
तो यही तो है।
नहीं ना, कुछ और भी है इसमें, हम बताएंगे नेक्स्ट डे हम बताएंगे।
मतलब नलिटी होगा आप
नहीं अभी हम कुछ नहीं बोलेंगे, अभी हम कुछ नहीं बोलेंगे, अभी हम कुछ नहीं बोलेंगे। कम से कम 8-10 जजमेंट हम रखे हुए हैं हमारे फेवर में, आज हमसे छूट गया है।
हमको भी साइटेशन है, हम
हाँ दे क्यों नहीं देंगे, यहाँ
सेटल
थोड़ी ना होता है।
IA number 111 of 2026 and SA number 64 of 1995. This petition has been filed by submitting that the judgment, the impugned judgment passed at the first appellate court is a nullity, as the defendant number 16, who is respondent number 9 in the present case, had expired in the year 1994 during the pendency of the first appeal. The case was arising out of the partition, which was decreed.
It's dismissed initially.
It was dismissed on 28/5/1985, against which the appeal was allowed by impugned judgment dated 9/8/1995. The counsel for the respondent submits that it's a legal issue and he shall advance his argument on the next day. He submits that the matter be posted in the next week. Post on Monday, first case at 10:30.
But Monday छुट्टी not Tuesday.
Tuesday.
27.
27.
27 जो लॉट पे अभी वो वाला केस फिक्स किया 10:30. तो इसके बाद
कौन सा केस फिक्स किया?
ये सर अच्छा नहीं 27 सेकंड 22 हो गया.
27.
हाँ ठीक है 27.
As first case 10:30.
Yes.
The counsel for the at this counsel for the petitioner has submitted that he has already annexed a copy of order in support of his plea. The counsel for the respondent is directed to forward advance copy of the judgments which he seeks to decide prior to the next day.
Yes. हम आज ही अभी
हमको भी दे दीजिए उधर भी.
हाँ वहाँ भी
हम दो ही पढ़ लेंगे.
कोर्ट मास्टर साहब को दे देंगे, मेरे पास है मोबाइल, हम भेज देते हैं। हाँ दे देते हैं, बस 5 मिनट में।
Item 3, second bill 23 of 1999.
Appealant.
Please, Your Lordship. Last order may be taken for consideration. Order dated 4th September 2025.
Yes.
Para 6.
Yes.
However, Mr. Amit Kumar Keshan, advocate, has submitted that he shall file document in connection with the death of respondent number 2 and also provide the names of legal heirs and successors of respondent number 2. So far, no such petition has been filed.
So,
Respondent number 2 has died now.
when?
It is he has to provide the details. It is not known to me. He is totally.
So the case will go on.
What can I do unless and until information is given to me? I will file an
Who is
application.
respondent number 2?
He is Mohammed Yasin.
How is he related to you?
The suit has been filed for declaration of title. However, both the learned courts below have converted it into a partition suit. And they say that he
Respondent number 2.
My Mohammed Yasin, son of late Maula Bakhsh. The third case is made out that he is one of the descendants of the common ancestors, which has been vehemently denied by the appellants. The appellant.
Where is Mr. Amitesh Kumar Yasin? Now, We are living in the same moment. Yes.
That is their claim. That is their claim.
Do you want to dispute it?
Yes, ma'am. He does not live in the same home. He is somewhere in Baridi or some Jaridi.
So, but the notice was issued to them only. And they have appeared pursuant to service of notice.
Ma'am,
They?
what they claim is that one of the original defendant, respondent number 3, I claim that she is my tenant. तो उसी के एड्रेस पे गया हुआ और वो वहाँ पे रह रही है मेरे सूट प्रीमिसेस पे रह रही थी and she has purportedly executed a gift deed along with respondent number 2 in favor of respondent number 1.
Notice was issued to respond number 2.
Initially,
He was
they have
appearing?
appeared.
He was appearing?
But he used to appear. He used to be represented by, as informed, Mr. Lalji Sahai earlier. Para 7 of the same order records the same.
He had expired in.
Yes, ma'am. That
This is
is
the information given.
that is the information, but the details of the representatives' legal address has not been provided.
You
Once
see,
we
there
will-
is no affidavit on record. This statement has no value. We will not take this statement.
Previously, yes.
There is nothing,
Yes.
there is no affidavit on record. He undertook to file an affidavit, but this defendant, this respondent is not filing an affidavit.
Ma'am,
The counsel is also not appearing. So you just, will issue notice to them. Or you file a substituted service affidavit for substituted service.
substituted means of service petition. That is the-
He was appearing by, through, Mr. Lalji Sai was appearing for him.
As he has informed, as he has informed. Also, we want
Essay number 23 of 1999 is better. The counsel for the applicant refers to order dated 4/9/2025. And he submits that. An oral submission was made by Mr. Amitesh Kumar Gerson, advocate, that respondent number 2 has expired in the year 2000, and that the respondent number 1 shall file an affidavit giving the details in connection with death of respondent number 2 and also provide the names of legal heirs and successors. Today, when the case is taken up, Mr. Amitesh Kumar Gerson is absent. Who had appeared for respondent number 2 earlier? 1 and 2, Mr. Lalji Sai.
One, it is recorded as per Mr. Nitesh Kumar. For respondent number 2, there is no difference. So for respondent number 3 is
So
concerned.
respondent number 2 had appeared by filing Bakala. He had appeared. Bakala Tama did the respondent. Mr. Rajesh Sai had appeared.
Since 2013, nobody is abusing correspondence. Even on one day, name of one Mr. Raja Kumar is the one.
The legal counsel for the appellant, in absence of any affidavit on record. Yes, Mr. Why are you so casual about your case? Where is your affidavit?
Lordship, I have procured the document of death certificate, my lord. Since, my lord, in the year 2000, my lord, there was no procedure for making death certificate, so a register was maintained in the madrasa, my
What
lord.
about the legal years?
My lord, sir, I'll provide every detail.
When? This is 1999 matter.
Yes, my lord. Since I was in procuring the document of death, my lord, showing the actual date of death, my lord. That register I have procured from the relevant madrasa, my lord, where it was recorded.
When did he die? 2000.
I'll file, my lord, within a week, lordship.
How much time do you need?
1 within a week.
Likhit person. Essay number 23 of 1999 will be valid.
3/1/2001, lordship, the date of death.
2001.
Yes, my lord. 3/1/2001.
Mr. Amitesh Kumar Yasin prays for time to comply the order dated 4/9/2025. He submits that the date of death has been obtained from the concerned madrasa
Barwadi Kabristan Committee, lordship, yes.
from Barwadi Kabristan Committee,
Yes,
and the date of death is date of respondent number 1. Respondent number 2 is 3/1/2001. उनका फादर्स नेम भी लिखा होगा ना?
yes, lord. Mohammad Yasin, पिता मौला बख्श.
He submits that the matter will be posted in the next week. Post on Wednesday. The affidavit will be filed by Tuesday.
Item 4, second appeal 97 of 2002.
But in this case, in IA Blood's notices were issued to the legal age of respondent number 3D, but the service report still says it is pending, awaiting tracking. In IA number 10084, it was issued.
Respondent number 3.
3D, legal age of respondent number 3D, who have been arrayed as 3D-A to 3D-C. Last office note number 17 January. ऊपर में
कहाँ के रहने वाले हैं?
ये तो आइए फाइल की ऑर्डर 22 10 का फाइल ये नोट है
The essay number 97 of 2002. The notice issued upon the legal years and successors of 3DA to 3DC through speed post has not yet been served. Counsel for the appellant is directed to take first steps for service of notice upon the proposed legal years and successes of respondent number 3D. In IA number कौन सा होगा?
IA 10084.
In IA number 10084 of 2025 through the concerned police station for which the request is be filed by Friday. Post on 17th awaiting service.
Sorry to mention, Lordship, for serial number 2, Lordship, from the supplementary list. We were unable to mark the list, Lordship. So I was praying it may be only adjourned for the day. It may come in the next week.
Post tomorrow.
Tomorrow.
Yes.
Because in this
Now
case.
you have marked the list?
Yes, Lordship. In this case, what has happened, Lordship, notice was issued. State, इसमें SR has come that they have not accepted the notice. SR का कोई आया नहीं है report. So for that it may be adjourned for SR report. ऑफिस को OP को डायरेक्शन था.
किसका नोटिस नहीं आया?
नहीं, ऑफिस को डायरेक्शन था. For serial number 2, Lordship. Order dated year over 9/7 year 2025. Since it is a government of office is directed to issue notice to private respondent 5 to 10.
Okay, we shall issue notice.
Yes,
But the point is that when you are relying upon certain judgment passed in the trial court and the appellate court,
Yes, sir.
why should the private respondent be saddled with the liability to produce those judgments?
No, we will file that document. We will seek
File it
instruction in
when
that regard. For only that only I was
When
speaking. It may come in the next week, Lordship. We will seek instruction from the client. It has come in the supplementary or
Yes, I appreciate
we
that,
were
but
not
draft
able to-
judgment you have to file, no?
Yes,
Because
Lordship.
you want to rely on
I
that.
think we have the judgment. It may come only in the next week. In the meantime, if it is in the file, we will file the supplementary.
WBC number 6025 of 2001. The counsel for the appeal petitioner has submitted that the notice was directed to be issued upon respondent number 5 to 10 through the concerned police station, but the service report has not yet been received. The counsel for the respondent state has no instructions with regard to affidavit regarding service of notice. Counsel for the petitioner is directed to take fresh steps for service of notice upon the private respondent number 5 to 10 through the concerned police station, for which refuses to be filed by Friday. Let a copy of this order be also forwarded to the superintendent of police of the concerned district. Concerned district of Hazaribagh,
Hazar.
to ensure that the concerned police station does the needful and the affidavit regarding service of notice is promptly filed before this court. The counsel for the state is also directed to seek instructions in the matter. Counsel for the petitioner has submitted that he shall the counsel for the petitioner has submitted that prior to the next date he shall file a supplementary affidavit annexing a copy of judgment rendered in title suit number 30 of title suit number 30/48 of 1955-56 and title appeal number 35/3 of 1957, whose reference has been made in order dated 9/7/2023. Post on 11 February of 1860.
File your.
By Friday.
Sunday, holiday.
Friday is holiday. You file it by Thursday. Friday is a holiday.
Friday is holiday.
By Thursday you file it.
My Thursday.
From daily Saturday 5, second appeal 170 of 2002.
In this case, the notices were issued to the respondents notes. Mechanistic service report.
हो गया वो तो फाइनली डिसाइड हो गया वहाँ पे या फिर नहीं तो भी
डिसाइड तो हो गया
डिसाइड तो हो गया या बिन नाउ रेंडर
बिकॉज़ नोटिस के लिए था आईए फाइल के लिए
क्या चीज की बात
इन दिस केस लॉर्डशिप द sole respondent Supriya Majumdar died during the pendency of this IN number 13753 of 2024.
When did she die?
23/10/2018. Paravon Lords.
What happened to the solicitor? सब वहाँ पर भी नहीं सब्स्टिट्यूट हुई Has she vacated the premises?
No, I am still in position.
Or you are in possession? You are the landlord.
I am the tenant.
Right. What is the service report? It has not been. 1A to 1C has been delivered, but 1B has returned back.
Time take place step to so far 1B is concerned. In present and correct it is not.
Why has it returned back? 1B कौन है?
1B है सुहिता मजुमदार इन्हीं के क्लाइंट हैं सुहिता मजुमदार
Why has it returned back? क्या लिखा है इसमें? आपके क्लोज रिलेशन है ना?
Yes, Your Lordship.
तो क्या हो गया? She has disappeared. Where is she?
No, Your Lordship. Regarding this, Your Lordship, no information.
What do you mean no permission?
No information, Your Lordship, regarding this returning of it.
आपके क्वेश्चंस का प्रेजेंट एड्रेस
है Your Lordship.
did he confess state for me present
आप हमको फोन करके पूछ के बताइए इनका प्रेजेंट एड्रेस क्या है?
ठीक
आइए फोन करके आइए 2:15 बजे
ठीक
Get in the text her present and correct address.
For final disclosure, item 6, second appeal 194 of 2006.
In this case, the interim order was passed on 9th December. We have challenged the order before the Supreme Court. I have also informed the court master yesterday.
Which interim order was passed? Order number?
Order number 550, order dated 9/12/2025.
Additional substantial question?
Yes.
It was framed.
No, no, no. Yes,
Where did you file it? Give me the details of your case number.
Diary number 3670.
Diary number?
3670.
3670 dated.
2026.
Some date must be there.
Yes, yesterday, 91.
SC number 194 of 2006. Counsel for the applicant has submitted that. Order dated 9/12/2025 has been challenged. Before the Honorable Supreme Court, bearing diary number 3670 dated 19/1/2026. Posed this case on 27 January. The SLP number is provided. Next. डायरी नंबर के केस डिटेल्स हमको पता
नहीं ठीक है, दैट वी नो नॉट।
केस
अच्छा, डायरी नंबर पे लिस्ट
एसएलपी नंबर
ऐसा 2 दिन और बढ़ा दो, क्योंकि नेक्स्ट वीक पूरा छुट्टी है, 23 24 25 26 4 दिन छुट्टी है।
27 की जगह 29.
Item 7, second appeal 107 of 2009.
Yes, appellant. क्या हुआ?
In that case, Lordship, the interim order was there till today.
Interim order passed earlier. Is directed to continue till your
The
next
next
date है उसका.
इसमें एक जजमेंट स्लिप हम दिए रिस्पोंडेंट की तरफ से।
आप आज का खाली एडजर्नमेंट स्लिप पर चल रहे हैं, हाँ? Your entire board is only adjournment slip. In all the cases adjournment.
This is first time I am doing.
What first time? तो सुबह से 4 केस में आपकी तरफ से adjournment हो गया। 3 हो गया।
नहीं कहाँ?
एक में आप फाइल छोड़ के घर में चले
एक
गए।
में फाइल बाकी सब तो पेपर कर रहे हैं।
अपील तो कर रहे हैं।
हाँ तो कर ही रहे हैं।
लेकिन कर नहीं रहे हैं।
नहीं कर रहे हैं, हम तो करते ही हैं। इसमें तो 2 वीक्स हमारे पास प्लेन डब्ल्यूएस कॉपी नहीं है, इनसे
बहुत
प्लेन
अच्छा
करते
बात है,
हैं।
नहीं है।
इनको इन्फॉर्म भी कल हम शाम को कर दिए।
इतना हम लोग टाइम नहीं दे सकते पुराने केसेस में। क्या है सब्सटेंशियल क्वेश्चन ऑफ लॉ बताइए।
ऑर्डर नंबर 3
इसमें आपको क्या है, कोई रिकॉर्ड का क्या जरूरत
है? प्लेट और डब्ल्यूएस की जरूरत
कोई जरूरत ही नहीं है। The only thing which we have to see is whether the appellate court has met with the reasons of the learned party. यही देखना है ना?
नहीं जरूरी है, प्लेट और डब्ल्यूएस जरूरी
है ना कोर्ट, आपके पास कहाँ से आएगा प्लेन डब्ल्यूएस?
इनसे हम ले लेंगे।
आपके पास है?
जी, इनसे हम फोटो करवा लेंगे। प्लेट और डब्ल्यूएस जरूरी है, इसीलिए जरूरी है।
Second appeal number 107 of 2009. Counsel for the respondent. Please for adjournment. To go through the records. Post day after tomorrow?
नहीं नेक्स्ट वीक नेक्स्ट वीक कर दिए।
इतना लंबा
नहीं बहुत हम पढ़े हैं, मेरा आर्गुमेंट भी तैयार है, मगर इसमें थोड़ा सा प्लेंट नहीं, इसीलिए अदरवाइज हम पूरा तैयार किए पूरा
नोट टुडे रहेगा तो नेक्स्ट वीक में आ जाएगा।
नेक्स्ट वीक किसी दिन पे रख दिया जाए, एनी डे।
Post on next Thursday. Thursday नहीं, आज Tuesday?
जी
Next Tuesday.
नेक्स्ट ट्यूसडे।
Item 8, first appeal 217 of 2024.
A short course of argument I have prepared in this matter. There is I'm going for adjournment this particular matter. Although I have communicated to client to obtain some deposition of client को obtain करने के लिए बस next week communicate करते हैं client को उसके बाद है. That is a matter of 24 only.
नहीं सुनना चाहिए।
एक वीक का लास्ट इंटेलिजेंस
एडजर्नमेंट नोटिस आप नहीं दिए हैं, मुझे आपका बात मानना है। एडजर्नमेंट नोटिस सर्कुलेट किए नहीं किए, फिर आपका बात क्यों मानना है?
एज ए लास्ट इंटेलिजेंस
Last chance हम देंगे on cost.
लोअर कोर्ट से डिपोजिशन वगैरह कुछ ऑपरेट करने के लिए क्लाइंट को अप्रोच किए बस वो लेके
एडवांस नोटिस नहीं है ना एडजमेंट का. Specific performance.
Yes.
Decreed or declined.
Decreed in favor of the plaintiff, that is the respondent in this case.
Execution
Ex
क्या
parte.
चल रहा है?
अभी execution का we are not aware. And without showing the readiness and willingness, the order, the judgment and decree has been passed. And the burden of proof never shifted upon the defendants, who are the appellants in this case. So onus is still lies on the plaintiff, and despite that decree and judgment has been passed against the plaintiffs.
FA number 217 of 2024. Counsel for the petitioner has submitted that the suit for specific performance has been decreed ex parte, and on the basis of the judgment, there is no finding in connection with readiness and willingness.
Section 16 of SRN is specifically
on the part of the plaintiff to perform his part of the contract.
Yes.
The judgment has been passed without taking into consideration the requirement under section 16
Yes. And even the burden of proof under
of
section
the
101.
specific agreement. Counsel for the respondent seeks adjournment. Completely. He submits that the matter will be posted next week. However, no advance notice seeking adjournment has been submitted. Considering the submissions, the matter is adjourned and is directed to be posted on next Tuesday, subject to payment of cost of rupees 1,000 to be deposited in Go Advocate Club Association. The receipt regarding deposit of the cost should be furnished latest by day after tomorrow, failing which subsequent.
The ladyship short period of argument is also there, are just provided.
उनको दिए कि नहीं?
नहीं दे
For hearing item 22, second bit 204 of 2007.
फाइल को दिए.
स्लीप दे दिया विक्रम
तब क्या करें? Responding from this. Who was respondent number 4? Then the plaintiff or the defendant? You are the plaintiff or the defendant? You are there in this case.
Yes, sir. We have got the response.
You are also seeking time. आपको भी टाइम चाहिए. कितना साल चाहिए? 2 साल. 2 years.
1 week.
बाकी लोग भी मर जाएंगे, कोई नहीं बचेगा. सबका सब्स्टिट्यूशन हो चुका है. नेक्स्ट जनरेशन का भी सब्स्टिट्यूशन होने वाला है. Counsel for the petitioner seeks appellant seeks adjournment. At his request, post this case on next Tuesday. Respondents are present. No further adjournment will be granted. Still मत दीजिएगा.
Item 33, second appeal 256 of 2007.
Final disposal में डाल दें. For final disposal. Final disposal में डाल दे रहे हैं. आइए for what?
In the list it is mentioned for miscellaneous, but file has been written.
आइए व्यक्ति क्या चीज़ समझ रहे हैं.
451625 2015.
Order 41/27.
The last order may also be seen. 17 July 25. Counsel for the appellants are directed to file a reply to the IA.
Order dated
17 July 25.
but you have not filed it.
Which we are the respondents. The appellants were directed to file a reply to that.
It is your IA.
Yes, sir.
You have not filed a reply to that. In spite of order dated 17th of July 2025, no reply has been filed to IA number 4516 of 2015. Order है उसमें order का क्या reply फाइल करना. We'll see. Proceeding dismiss हुआ है, allow हुआ है. Final disposal में डाल देते.
Item 33, second appeal 256 of 2007.
Reversal.
What is the question of law?
there is
कोई बात नहीं, कोई तो फाइल खोलिए ना.
हाँ.
Where is the respondent? Respondent?
Preparing for respondent, requesting this case simply to second application.
Second house is a different board.
Senior Sugito do is on his legs in co-pilot.
Sit and listen to the arguments.
Yes.
The question of law was formulated on 20th August 2009. Defendant, respondent, applicant. What's your
There is no abatement?
No.
Alright. Okay. Yes, yes. बताइए.
Next week आज 2-3 केस ऊपर में था उसमें।
अब कहाँ कौन सा केस किए?
आज किए नहीं हुजूर तो
2-3 केस ऊपर में ऐसे
दूसरे कोर्ट में। एडवाइस वुड डाउन विजुअल इज देयरफॉर हम लोग को लगा नहीं क्या स्टेक अप होना था। वेरी जेन्युइन थिंग।
ये बात है।
हाँ। जनरली कोलैप्स होता नहीं हुजूर, आज हो गया कोलैप्स लिस्ट। फर्स्ट वीक ऑफ इसमें फरवरी में रख दिया जाए।
हम सोच रहे हैं आप सिविल केस छोड़ के खाली डीटी कर
नहीं
आप लोग को इंटरेस्टेड नहीं है?
हम लोग व्हाट वी वर थिंकिंग मंडे
हम भी
ट्यूसडे
वही सोच रहे हैं कि अब रीड का बेंच है, हम आराम से रीड करेंगे।
नहीं,
आपको
नहीं,
क्या जरूरत पड़ा है सिविल केस करने
2 दिन तो हुजूर हम लोग
पार्टीज आर यू सी सुबह से कर रहे हैं।
हाँ।
एक भी केस का डिस्पोजल नहीं हुआ है,
आज नहीं।
राइट?
फर्स्ट केस तो काफी देर चला।
काफी देर चला, वो कंटेस्टेड था तो चल रहा था। द पॉइंट इज दैट द पार्टीज
नहीं,
आर नॉट इंटरेस्टेड, एडवोकेट्स आर नॉट इंटरेस्टेड।
हम लोग
2007 का केस हम क्यों सुने?
नहीं हम लोग एकदम
आप देखिएगा ऐसा बेंच बनाएंगे जिसमें एक भी केस टेक अप नहीं हो आपका फर्स्ट अपील।
हम लोग रिक्वेस्ट कर रहे हैं हुजूर 2 दिन कम से कम सेकंड अपील के लिए स्पेसिफाइड रहना चाहिए और 2 दिन रिट के लिए दैट इज सफिशिएंट।
करेंगे नहीं ना आप लोग?
नहीं करेंगे हुजूर, 2 दिन
स्पेसिफाइड करके क्या होगा?
नहीं
सब जानते हैं।
एवरीडे लगभग हम लोग तैयार हो
अपना
गए।
जो 2007 से केस चल रहा है इसीलिए चल रहा है क्योंकि आप लोग किए नहीं।
27 को रख दिया, 27 एकदम मंडे को, ट्यूसडे को रख दिया, 26 छुट्टी है, मंडे को रख दिया।
आप कौन है?
ये हमारी तरफ से अपीलेंट है, हमारा सीनियर।
कुछ कंफ्यूजन?
नहीं
27 को करेंगे।
ठीक।
रख तो दे रहे हैं लेकिन क्या टेकअप होगा?
ठीक है, वो तो लिस्ट देख के हम लोग समझेंगे, बट हमारा एज जस्ट रिक्वेस्ट है कि 2 दिन कम से कम सेकंड अपील रहा है, 1 दिन मिसलेनियस मैटर और 2 दिन
नहीं अब तो हम खाली लेटी हम सोच ही रहे हैं।
हम लोग का डिफिकल्टी
हटा देंगे सब, हमको क्या जरूरत पड़ा है? व्हाई शुड आई बॉदर? आई एम नॉट इंटरेस्टेड इन दोस केसेस वेयर पार्टीज आर नॉट इंटरेस्टेड। थोड़ा दिन में सब अवेट हो जाएगा, सब ऐसे ही हम लोग डिस्पोजल कर
27 तो ठीक है, 28 को कर लीजिए।
28 को एक स्पेसिफिक केस फिक्स थे उसे वही बता रहे थे कोर्ट नंबर 3 में 28 को कर दिया।
with the consent of the learned counsel for the parties close this case for final disposal on 20.
Top of the order is top of the list.
Top of the list.
हाँ।
आप डिसाइड करेंगे कौन सा केस का टेकअप होगा।
नहीं आप कंपेयर करें।
ऐसा नहीं कर सकते। I just do not know how the हो सकता है उस दिन कोई केस ही आपका पूरा 4 बजे कर देंगे फर्स्ट अपील सेकंड अब पूरा दिन रीड करेंगे
जैसा कन्वीनियंस हो।
आप लोग को वही कन्वीनियंस है।
नहीं यार मुझे भी कन्वीनियंस चलेगा।
जैसा आप लोग के कन्वीनियंस की बात सोच रहे हैं कि सब केस ऑटोमेटिक सब एडजर्न हो जाए।
नहीं एडजॉर्नमेंट के लिए हम लोग टाइम नहीं होता।
इतना डिस्पोजल हुआ है तो लास्ट 1 ईयर।
अब इतना आप बिजी रहते हैं, आपको कहाँ टाइम मिलेगा यहाँ कोर्ट में आने
नहीं,
का?
नहीं,
क्योंकि यहाँ आइएगा तो हमको समझने में बहुत टाइम लगता है।
हमको करने के लिए
सब जगह से छुट्टी लेके आना पड़ेगा।
हम लोग तो यहाँ करने के लिए तैयार हैं।
Many cases lordship in last 1 year we have got disposed of by lordships. हम लोग को भी लग रहा है कि now
कितना
things are
मुश्किल से
moving.
सब लोग तैयार हुए
Yes,
हैं,
yes.
हम ही को पता है।
नहीं बेसिकली जो प्रैक्टिस यहाँ जनरली कर रहे हैं हम लोग तो रेडी होते ही। We know what lordship thinks wants. Therefore we are ready at least 1-2 cases every day.